Good morning, everyone. Welcome to today's hearing. Today we're going to continue hearing evidence from Mr. Simon Cash. Would you like to ask Mr. Cash to come in, please?
Morning.
Morning, Mr. Cash.
Morning.
All right, all ready to carry on?
Yes.
Good. Thank you very much. Yes, just get yourself organised. Yes, Mr. Willett.
Good morning, Mr. Chairman. Good morning, Mr. Cash.
Morning.
I want to continue the line of examination that we were on last night and turn to the question of the quantity surveyor for the Grenfell project. Now, is it right that that was Chwichin Lim until October 2015, when Michelle took over until the agreement of the final account in June 2017?
Correct.
Yes. And you are, I think, by profession, a quantity surveyor, are you not?
Correct.
And you supervised Chwichin Lim, didn't you?
In capacity as her line manager, yes.
You did. And can you just tell us, as briefly as you can, what it is that a quantity surveyor does normally?
A quantity surveyor actually estimates the cost of carrying out works, and then is also responsible in some instances for procurement of works, and then for managing the costs during the construction of the works and agreeing the final account.
And what about advising on variations?
Yes, that's part of managing the cost of works.
Yes.
And also any changes in the design that may occur prior to the appointment of the contractor.
Are there any, or were there any, to your understanding at the time of the Grenfell Tower project, any special considerations that would apply to a design and build contract from a quantity surveyor's point of view?
Nothing particular. It was a standard design and build contract.
Okay, well, we'll come back to that later on. Can we look at Artelia's contract again, please? That's ART 405742 at page 55. And here we see the core services. This is page 1. And at page 55, we see core services of a QS, a quantity surveyor. This is the first page, I think, of the RICS QS standard terms. Or rather, this is the first substantive part of it. If we go down to page 57, we can see that there are additional services there, supplementary services for design and build contracts. Could you look at tick box 1.8.1 first of all, please? It says, liaise with the client and the professional team, both as defined, and prepare the employer's requirements. What does the quantity surveyor do normally in terms of preparing the employer's requirements?
It collates documents from other members of the professional team and relevant documents that are required that then will be form part of the employer's requirements, and also prepares a set of preliminary documents, which is one of the composite documents, and also a cost contract sum analysis. I
see. If you look at tick box 1.8.3 and then 1.8.4, look at those together. 1.8.3 is about liaising with the professional team and preparing cost studies to assess alternative contractors' proposals and prepare a recommendation for the client's approval. And 1.8.4, liaise with the professional team and assist with specialist inquiries to assess alternative contractors' proposals, prepare recommendations for the client's approval. Looking at both of those, when a quantity surveyor assesses a contractor's alternative proposal or proposals, what should they do?
They'll be looking at the financial aspects of the alternative proposals compared to those that are in the employer's requirements.
Solely the financial aspects?
Yes.
Looking at 1.8.5, it says, liaise with the professional team and conduct negotiations with the contractor, obtain documentation from the professional team to confirm the agreed design and or performance specifications, prepare recommendations for the client's approval. And when it says obtain documentation from the professional team to confirm the agreed design and or performance specifications, what would a quantity surveyor do in that respect? What would that include?
It would be the gathering of the documents from the professional team.
What documents
whatever
think that would
documents the
include?
professional team had prepared that relate to design or performance specifications.
Right, I see. Now, we talked earlier on about Artelia's contract with the TMO having been signed in July 2014. It's right, I think, isn't it, that Artelia and the TMO agreed a number of additions in the 2014 version of the contract?
Yes, that's correct.
Yes. And while we're still on this page, this is the 2014 signed version of the contract, while we're still on page 257 here. And if you look at 2.1.9 under supplementary services, which is the only box in that run other than one at the top of the page, which has been ticked, the rest are blank. 2.1.9, facilitate, set up and manage value engineering exercises. And just for completeness, you can also see that 2.1.11 has been ticked as well. But just on 2.1.9, value engineering exercises, when did it first become apparent to Artelia that Artelia would need to assist with facilitating and managing a value engineering exercise on this project?
I'm not sure when specifically, but it would have been at a time when it was identified that the cost of the works that had been estimated exceeded the TMO's budget that was available for the works.
All right. And I think it's right that certainly by March 2014, at the latest, on evidence we've already seen in the inquiry, value engineering was a key, or at least an important feature of this project. Would that accord with your recollection?
Yes.
Now, can we just go briefly to Tweech and Lim's witness statement number 2? This is ART 409428. This is her second witness statement to the inquiry, and I just want to ask you something about what she says about the role of a QS, quantity surveyor, in this exercise. Can we look at page 19, please, and go to paragraph 56? She says there, as QS, it is part of my role to facilitate, set up and manage value engineering exercises, so I will be involved in discussions about reducing costs. Do you agree with that?
Yes, but that was the particular aim of the value engineering, was to try and see if there were alternative options that might reduce costs.
Right. What would a QS's involvement be in a value engineering exercise?
It would be to actually evaluate the financial effect of any suggestions that were being made by the professional team.
Right. So evaluation of the financial effect of suggestions made by the professional team. What would a QS do to facilitate a value engineering exercise?
Set up a workshop that would involve the client and the professional team and any other relevant members to then identify and bring to log suggestions as to where potential value engineering might be achieved.
I see. Now, you said log suggestions, and where would those, well, we're on that answer, where would those suggestions be logged?
They would be kept in a schedule.
A schedule to what?
It could be a spreadsheet, it could be a written format, but it would be a schedule of ideas, and it would then the ideas could then be reviewed in terms of their technical evaluation by either the professional team, and also looked at in terms of the financial effect as to whether there might be a reduction in costs or even whether there might be a benefit which doesn't necessarily result in a reduction in cost.
Right. And there's quite a lot of detail that you've given us in that answer. So that would be a detailed document, would it?
Not necessarily, no.
Right. Who would be the custodian of that document? Who would keep it?
The quantity surveyor would be the custodian, yes.
Right. And who on a particular project would have access to that?
It would be circulated to all members of the team.
Right. And was one kept on the Grenfell Tower project?
It was kept in a log, yes, I believe, and there were ideas that were circulated.
Now, while on the subject of value engineering, and it's a subject we will revisit later in your evidence, Mr. Cash, but I just want to ask you about obligations at this stage. Can we go back in this document, go back in the contract, to the 2014 contract, to page 47. And on page 47, as you can see, this is core services, and you can see under page 49, we can see tick box 2.1.4 under supplementary services. And I should just say this is part of the contract dealing with the EA schedule of services, the employer's agent schedule of services, but it also talks about value engineering. And here you see on page 49, paragraph 2.1.4, which has a cross in the box next to it, facilitate, set up and manage value engineering exercises. What would the employer's agent do? So not the QS, but the EA, the employer's agent, do to fulfill those obligations?
In a similar way, that they would arrange for a workshop or a meeting that would bring together a professional team, and then act as a facilitator to record ideas that would potentially contribute to value engineering.
Right.
They're very similar.
They're very similar. Within Artelia, were those obligations discharged by the one person who occupied two roles?
Yes, I mean, at the end, in terms of distinction between the roles, because it was one company providing the service, that was an interchangeable service between people as and when who was actually responsible. So it wasn't split between one person doing one thing and one person doing another, because otherwise it would have been a waste of resource.
I follow. Who was the individual within Artelia who discharged or was responsible for discharging Artelia's contractual obligations, both as under the QS services and under the EA services, in respect of value engineering exercises?
The lead in terms of the value engineering was taken by, in the initial stages, by Alan Dawson as the employer's agent, and supported by Chui Chen in terms of the quantity surveying aspects of that.
I follow. Thank you. Can we then turn more specifically to the employer's agent role? You mentioned Alan Dawson just now. I think it's right that he was the individual within Artelia who had the role of employer's agent up to March 2013. Is that correct?
Yes.
And then there are a number of other people who occupy that role thereafter. I'm going to run through them and just tell me if any of these is wrong. March 2013 to July 2013, it was Robert Powell.
Yes.
July 13 to March 15, Philip Booth.
Yes.
And then March 15 to practical completion in July 2016, I think it was Neil Reed.
Yes.
Right. Now, looking at your first witness statement, if we can, please, that's ART 406544. I'd like to go to page 3 in that document, and we can look at paragraph 8 on that page under the heading EA Services. In the second sentence there, you say that an EA, employer's agent, is essentially an administrative role. And you go on to say an EA has the responsibility of monitoring the progress of a construction project and administering the contract. What administrative work does an EA do?
It's effectively identifying the progress of the works. It sets out to ensure that the design team, the professional team, are fulfilling their responsibilities in terms of making sure that they are delivering in accordance with the programme, that they are on track, and that actions are being carried out. In terms of the contract, there are references within the contract to the role of the employer's agent in terms of what their obligations are, in terms of the documents that they should issue, and generally administer on behalf of the employer the management of the contract.
Right. Does an employer's agent make substantive decisions relevant to a project?
Only on behalf of the employer, under the instruction of the employer.
I see. But in terms of those decisions, or examining the substance of those decisions, you've referred to making sure the professional team fulfill their responsibilities in terms of making sure that they're delivering in accordance with the programme, and also issuing documents. I can understand those two substantive ideas. Is there anything else that an employer's agent does on instructions normally from the client by way of administration of the contract?
If the client is requesting changes, then we will issue instructions on behalf of the client to the team or to the contractor.
I see. So change management.
Yes.
Right. Does an employer's agent provide advice to the client of any kind?
In terms, yes, there's certain advice which is provided within the scope of service. So, for example, in terms of procurement or tenderers and things like that. But in terms of, if you're referring to advice in respect of design, absolutely not.
I follow. So procurement, tenderers. What about budget?
That would be the realm of the quantity surveyor.
Yes, I see. Now, we saw earlier, in your evidence yesterday afternoon, in fact, that in this contract with the TMO, Artelia had deleted the role of project manager and project monitor. You remember that?
Yes, I do.
Can we look at Robert Powell's witness statement? That is ART 408984, please, and go to page 6. He was, as we've just established, the EA for the Grenfell Tower project from March 2013 to July 2013. And look at paragraph 27 on that page, at the top of the page there. And he says, the role of an EA is generally speaking to provide professional administrative assistance and representation to the client in the context of a design and build contract. This is different to a PM role, as a PM tends actively to manage a team to develop and deliver a project for a client, sometimes almost stepping into the client's shoes with the client's agreement in some respects. A PM will frequently be actively making decisions on behalf of the client. I understand that AUK did not have this role on the project. Instead, the client, the TMO, retained the PM, project manager, role for itself and was the decision maker. This is not unusual. Do you agree with what Mr. Powell has written there?
Yes, I do.
Are there any other differences between an employer's agent and a project manager over and above what Mr. Powell has identified there?
Not in general terms, no.
So would an employer's agent have similar skills to a project manager?
They could have, yes.
Yes. And could somebody who is appointed an employer's agent also be a project manager? It's possible to tick both boxes.
Yes.
Yeah. Is it less expensive in general, in your experience, for a client to appoint an EA, an employer's agent, and not a project manager?
I would say yes.
Yes. Can I then turn to the next subtopic, which is who the project manager actually was on this project? Can we go back now again, I'm afraid, to the 2014 contract, ART 405742, and go to page 23. This is Schedule 1 to the 2014 contract. And we looked at this yesterday afternoon, Mr. Cash. You can see that project manager services and project monitor services were deleted. What is the difference between project manager and project monitor?
There are different scopes of services that are identified by the RICS.
Can you give us an idea, in very short, brief terms, what the different scopes are?
I can't think of anything off the top of my head. I'm not particularly familiar with the project monitor scope of services.
Okay, fair enough. Now, would it ever be the case that a client would appoint a project manager and an employer's agent on a project?
Yes.
As opposed to having one or the other, but not both?
Yes, I'm currently involved in a project where that is the case.
I see. But for a project like the Grenfell Tower refurbishment, given its different complexities and different elements, what would you expect a project manager to do? Or maybe put it better, what would you expect project management services to include?
Project manager would be, as Mr. Powell had said in his statement, a decision maker on behalf of the client, and would have certain authorities to act on behalf of the client.
And what would those authorities tend generally to incorporate or include? What sort of things?
They might relate to decisions regarding types of design or progress in terms, or development of programs, in terms of making decisions on behalf of the client, in terms of budgets, in terms of acceptance of derogations to employers' requirements, or to value engineering decisions, rather than deferring to the client themselves to make those decisions.
I see. Now, you've referred just now in your answer to value engineering decisions. Do I take it from that in fact that could encompass decisions about particular products to be used in a value engineering exercise, or particular designs to be used in a value engineering exercise?
Possibly, depending on the project manager's specific scope of services.
I see. Okay. Now, we may come back to that later. If I can show you your first statement, please, at paragraph 22. This is on page 8. You say there that this is second sentence. Well, the minutes you're referring to the second design team meeting there. You say towards the middle of that paragraph, I believe that the project manager description, and this is a reference to a document, was a misuse of terminology, which also occurred on other occasions during the project. Mark Anderson, whose title was Director of Assets and Regeneration, and later Claire Williams of the TMO, were the project managers on the project. Now, you referred to a document which you say was a misuse of terminology, where that terminology was used. What was it that led you to think that Mark Anderson and Claire Williams were the project managers for the Grenfell Tower project?
That they were the ones that were making the decisions and that they were driving the project forward and dictating a number of aspects in terms of setting the budgets and the programs.
So you were of that view based on what you observed them doing. Is this right, as opposed to anything that they told you?
Claire Williams was actually introduced to the project as the project manager.
By whom?
I can't remember specifically, but I remember that it's recorded in a meeting.
Did you understand that Claire Williams... Well, let me ask you about Mark Anderson. What was it that led you to think that Mark Anderson was the project manager?
He was effectively the client's representative within the TMO who was managing the project.
Did he or anybody else at the TMO tell you that he was a project or the project manager?
Not specifically, no.
Right. Did you understand that Claire Williams and or Mark Anderson had taken on the project manager role in the same sense as the role as contemplated by the project manager obligations under the RICS terms?
I can't say that for sure, no.
No. So what did you understand her or their role to be as project manager?
In terms of the general terms as a project manager was my expectation. Obviously, I can't say specifically that they were taking on every role within the project management role of the services, RICS scope of services.
Yeah, so we'll come to a document in a moment, but can I just look at the RIBA services standard form, which did apply as between the TMO and Studio E. It says SEA 409824, please. Here it is, and you're familiar, I think, with the RIBA's 2010 services.
I'm aware of it. I'm not entirely familiar with it.
Okay, we've looked at it earlier on in this inquiry. We can see that at least in this project, if you go to page 2, please. Well, let's stick with page 1 for the moment. We can see on that page, here are the services. The project is the Grenfell Tower upgrade. The client is the TMO, and the architect is Studio E. And then let's flip to page 2, where I do want to go. And you can see there that under specified roles, the role of project manager is deleted. And then it says, if no project manager is appointed, then the client or client's representative performs the role. And then lead consultant services are always required, it says. So you could see that project manager is deleted. Were you aware of that?
No, I wasn't.
Right. So do we take it from there that you didn't know that Studio E had excluded the role of project manager?
Not specifically in that document, no.
You say not specifically in that document. Did you know otherwise, or from another source, that Studio E had refused to take on or had excluded the role of project manager?
Not specifically excluded it, no, but it is only in assumed terms.
You say only in assumed... You mean... I don't understand that last
in as
answer.
much as that they were the architects and the client was the project manager.
Right. I see. But as far as this contract goes, would you accept that, given that Studio E had excluded the role of project manager, as we can see, that would mean that at least as far as this contract goes, either the TMO or Artelia as the client representative would be the project manager.
It's in suggesting that Studio E are not the project manager, but as you say, one or other, yes.
Yes. Now let's go to the document I want to show you, which is ART 402255. These are the minutes of the contractor introduction meeting on the 1st of April 2014. It's a document we've seen a great number of times in the evidence so far. And in contextual terms, this is just after Ryden had won the job as the main contractor. But I should just tell you, some months before Ryden's formal written design and build contract was signed with the TMO. That was at the end of October 2014. And again, for context, this is about 2 years into Artelia's work on the Grenfell Tower project, and before Artelia's July 2014 contract with the TMO. So that sets it in its chronological context. Let's look at it. We can see the top half of the page. It's at the very top, in fact, on Artelia branded paper. You can see that. And these are the minutes of the meeting. They're dated or issued on the 4th of April 2014. You see that. And you can see who was you can see who was present, but you can also see above that, under quality, author Peter Blythe. He's Artelia. Yes?
Yes.
Yes, and checked by Philip Booth. He's also Artelia, as we know. We can see that lower down. And then you can see who was present. Now, just pausing there, do you accept that this is a document that was produced by Artelia?
Yes, I do.
Yeah. And Booth, Mr. Booth and Mr. Blythe were Artelia employees appointed to the project at that time, weren't they?
Correct.
Now, let's go down the cast of those present. We can see that there are 3 TMO people present, Peter Madison, David Gibson and Claire Williams. And then immediately below that, we can see Philip Booth, company Artelia, function project manager. You see that?
Yes.
And Peter Blythe calls himself the assistant project manager. Now, my question is this. If Artelia was not performing or not intending to perform project management services, can you explain why they have called themselves project manager or assistant project manager in this document that they produced?
I can't explain why they've done that, although those would refer to their business titles, and therefore that may well be a reason why those have been used in error.
I see. If you look at the top of the page, you can see that under objective, the second item down under project, introduce the successful contractor to the client. And then if you look and see who the client was under those present, it's Peter Madison, David Gibson and Claire Williams, function client in each case. So if this document was then circulated to all main contractors, and certainly to Ryden, all the people from Ryden, would you accept that this document would be at least telling Ryden that Artelia had the role of project manager?
Potentially.
Let's go to ART 401496, please. Before we do, can I just ask you, you said earlier on in your evidence that Claire Williams was introduced as the project manager to you.
Yes.
In fact, looking at this document, not this one, but the 1st of April document we've just looked at, in fact, she was introduced as the client, and it was Artelia who was introduced as the project manager.
I don't necessarily believe that they were introduced at the meeting as project managers, but they were identified there as project managers.
Right. I don't think you were at that meeting, were you?
No.
Right. So how do you know? What is the basis of your belief that they weren't introduced at the meeting as project managers, given what they've written in the minutes?
I don't believe it says so within the minutes.
Well, let's look at this. Let's look at the.
Sorry, 1.2.
Okay. Well, let's go to that while we've got it on the screen. Looking at 1.2. That says ART, represented by PB, that's Artelia represented by Philip Booth, will perform the role of employer's agent on the project. Yes, I mean, I don't think there's anything in there that specifically says that Artelia will not be the project manager. Do you think there is?
No, but it quite clearly states what the role is.
Yes, it says what it says. One can argue about its true construction, I suppose. But would you accept that there's nothing in this minute which would tend to contradict the idea communicated by Phil Booth and Peter Blythe's role, described as project manager and assistant project manager, that Artelia were not that Artelia were the project managers on the project?
There's nothing that says that they're not. Okay.
No. Now, let's go back to the document I want to take you to. ART 401496. These are the minutes of a design team meeting of the 23rd of September 2013. 24th of September 2013, I apologise. And again, we can see that Artelia took the minutes. It's Artelia note paper. And again, the author is Peter Blythe, checked by Philip Booth, both of Artelia. And again, in the middle of the page, we can see that Claire Williams and the others from the TMO are introduced as the client. And again, towards the bottom, Phil Booth and Peter Blythe, project manager and assistant project manager. So you see that.
Yes.
And there's another one. So again, in 2013, this is earlier in time, both of those individuals are introduced as project manager and assistant project manager. And before I ask my question, I'll show you one even earlier document. This is ART 6037. This is the minutes of design team meeting number 2, Thursday, the 24th of May 2012. Now, you weren't there, but you can see the bottom half of the page at paragraph 1.0. That Alan Dawson is there, and under introductions generally it says Alan Dawson is introduced as the project manager, assisted by David Hale. So, looking at the two documents I've shown you, 23rd of September 2013, May 2012, from the very earliest days of Artelia's involvement in this project, Artelia did introduce itself as the project manager, didn't it?
These minutes were produced by Studio E, I believe.
Right, but they were distributed, I'm assuming, to those who were present. Is that wrong?
They would have been, yes.
Yes, and that would mean that Alan Dawson and Keith Bushell and David Hale and Chweech and Lim would have seen these notes, yes?
Yes.
And if it were wrong and Alan Dawson hadn't introduced himself as the project manager, then would I be right in thinking that one of them would have raised that and said that the note was inaccurate?
I don't know if he did.
No, but I'm asking you to agree with the proposition that each of them, or any of them, having seen this, would have corrected it if, in fact, Alan Dawson hadn't introduced himself as the project manager. Do you accept that as a proposition?
Potentially, yes.
And I don't think you've seen any document, and certainly we haven't seen any document, which says that any such correction was suggested.
I haven't seen one, no.
No. So can we proceed on the basis that this is an accurate record of what was said at the meeting by way of introduction of Alan Dawson?
It's a record of what Studio E have recorded.
And I'm putting to you that, given the absence of any correction, can we proceed on the basis that Studio E recorded it accurately?
If it's not been challenged in writing, yes.
Yes. Yes. Having shown you a number of documents and the absence of correction of those documents, do you still say that Mark Anderson and Claire Williams were in fact the designated project manager for this project?
Yes, I do.
Given the way they were introduced?
Yes.
And why do you say that?
Because that's the way that they've just been recorded as attendees at a meeting. It's not necessarily the way that they fulfilled their functions.
Right. Can we go to your first witness statement at page 8, please? Paragraph 22. Now, you say there, and we've seen this a moment ago, or not a moment, but a few minutes ago, you say that using the title doesn't mean that they are project managers for the project, and it was their job title at Artelia that was project manager, not their role on the project. Having seen the documents I've shown you, did you ever take any steps yourself, personally, to clarify with anybody that the use of the title project manager was only a reference to an internal job title within Artelia and not a reference to the status of that person on the Grenfell Tower project itself?
I can't remember any specific instances. I would have made it quite clear to the internal team that we were employers' agents and we weren't project managers, though.
Right. I mean, you can see, can't you, how the possibility of confusion might have arisen at the very least.
In those particular instances, possibly, yes.
Yes. Can we then go to ART 409032? ART 409032. This is a draft revised project brief as at May 2013, and we know it was written by Robert Powell of Artelia, and it's dated the 1st of May 2013. I don't need to show you the precise date at this stage. Now, at this point, May 2013, TMO were considering whether to continue with Leadbitter as the contractor for the Grenfell Tower project, weren't they?
Yes.
Yeah. And if we look at page 2 of this project brief, if you look at the first half of the page, in the first paragraph, last sentence there, I pick it out, it says, Appleyards, that's as Artelia were at that stage, who had previously acted as EA/QS, will take on a full PM, project manager, EA, employer's agent, role, in addition to their QS responsibilities, and will fulfill the lead consultant role. Now, I'll come to a question in a moment, but before I do, I want to just show you something else in this document. Page 4, it says in the top half of page 4, under the heading Project Team, that's the bottom half of the text, with the top half of the page, it says, Robert Powell is proposed as the project manager, and you are proposed as the project director, under the word client, and that's Peter Madison at the TMO. Just looking at that document and taking those two pages together, would it be right that at this point, Artelia was actually proposing to project manage the refurbishment?
There was a proposal to do so, but this was a draft document, and the offer of doing the project management services and lead consultant role was never taken forward.
Can we then go to ART 401219, please? This is a further draft of the same document as at June 2013, a revised project brief, again produced by Artelia. Do you remember who produced this document?
I can't remember, no.
If we look at page 5, you can see there is a space for it's a signature, signed project director, and project director is identified as you, Mr. Cash. Do you see that?
Yes.
And again, project manager, Robert Powell and Philip Booth. Do you remember whether you signed this document?
I don't believe I did, no.
Did you see it at the time?
I can't remember.
You can't remember. Well, while we're on this page, as I've shown you Robert Powell and Philip Booth being designated as project managers, can we go to page 2 of this document? Because they're designated as project managers. Do you remember whether they signed it as project managers or not?
I don't believe they did. This was a draft document still.
Okay. Well, let's go to page 2. Under contract and procurement, if you look at the third paragraph down, it says, in 3 lines down from that, Appleyards, who had previously acted as EA/QS, will take on a full PM/EA role in addition to their QS responsibilities and will fulfill the lead consultant role. So again, that language remains in this June draft as we'd seen it in the May version of this draft. Do you accept at least this much, that at this stage, June 2013, Artelia was proposing to act as project manager in the strict sense, properly so called, on this project?
Yes, there was a suggestion.
Yeah. Then let's move a little bit forward in time, perhaps at the same time. ART 409106, please. This is a TMO meeting, 6th of June 2013. And I say it's a TMO meeting because that was the meeting title, as you can see from the top of the page 1, on the Grenfell Tower project. And the date and the time of the meeting was the 6th of June. Again, an Appleyards document. Again, author Philip Booth, checked by Robert Powell this time. And you can see who was present. 3 from the TMO, Madison, Gibson, Dunkerton. And then you're present as project director, and then underneath that we have Robert Powell and Philip Booth from Appleyards, as they then were, identified as present as project managers. You see that?
Yes.
And then below it, in item 1, it says approval of revised project brief. You see that? That's the document we looked at.
Yes.
PB presented the draft revised project brief. It was agreed to insert overall project costs, including fees and surveys, not just construction costs. Subject to the proposed changes, the brief was approved. You see that?
Yes.
So it looks from this as if Artelia was approved as project manager, not only because of the way in which Mr. Powell and Mr. Booth were designated in this document, but also because the revised project brief, which I've just shown you, in the page I've shown you, identified Artelia as such. Do you accept that?
Sorry, say that again.
Well, I'll try it a different way. It may have been a long question. It looks as if the draft project brief I was showing you before, which said that Artelia was going to take on the project manager role, was approved at this meeting.
Subject to comments made on the attached.
Subject to the proposed changes, yes. I don't think that the comments had anything to do with the status of Artelia acting as project manager.
In terms of what was approved at the meeting,
Yes.
but it wasn't actually formally taken forward still.
So you're saying that it was formally approved at the meeting, but not formally taken forward.
Correct.
Is that your recollection?
Yes.
I see. Were there any discussions with the TMO at this time on whether Artelia was to act as project manager, as proposed in the revised project brief?
I can't remember.
Right. And was that draft proposal ever acted on? You say it wasn't taken forward. Was none of it taken forward, or was some of it taken forward?
I don't know.
You don't know. Right. Let's go to... well, I'm just wondering whether or not something changed in July 2014 when the formal contract changed, or formal contract was entered into.
I don't think anything changed. It was, as far as I was aware and concerned, it had always been that we would carry out the roles of the three particular services that were offered: CDM coordinator, quantity surveyor, and employer's agent. And that whilst there had been a suggestion that Artelia might take on the project management role in relation to the moving forward on the project, it was never taken up.
Right. Well, let me try it a slightly different way. You say it was never taken up. We can certainly see what was the subject of specifically the contract in July 2014, or we've seen the deletions there.
Yes.
What I'm really getting at is whether or not there was a period between June 2013 and July 2014 where, at least according to this document, Artelia did act as project manager.
I don't believe that we did. There was a suggestion that we would in the draft briefs. In that period of time, which was, I believe, was the standstill time when the status reports were prepared, there was a specific brief that we identified certain activities that we would carry out, and that was done in a letter.
Can I just ask this? It looks to me from the documents we've been reading that it was agreed in principle that Artelia would become project manager, and then subsequently, when the contract was formally drawn up and signed, the project manager role was deleted. Now, it may be Mr. Millett wants to ask you about what occurred, but do you recall some sort of discussion taking place which explained why there was that change in approach?
No, I don't. The project management role was always excluded.
Well, it wasn't excluded at this stage, was it? Because we've just seen that there was a meeting at which the proposal that you should take on the project manager role seems to have been approved or agreed in principle.
As an addition to our role, because
Well,
our
right.
2012 offer was always exclusive of project management.
Right. Yes, Mr.
Yes. Just coming back on that, you say the 2012 offer was always exclusive of project management, but in fact, just on the documents we've seen, the way in which people from Artelia were introduced, particularly at this meeting, and the adoption, according to this document, of the revised project brief in June 2013, the documents suggest that it was at least possible that Artelia had taken on the role of project manager between June 2013 and July 2014.
I don't believe that we did.
Right. Was there any discussion, so far as your recollection goes, between Artelia and the TMO about the fact that even though the revised project brief we've just seen was adopted and approved at this meeting, which included a proposal that Artelia would act as project manager, nonetheless, in fact, Artelia was not taking up the project manager role?
There was never any discussion of what any additional services might be required to make Artelia a project manager.
That may be, but my point's a narrower one. We've seen the revised project brief and the proposal to take up the role of project manager stroke EA. My question is, was there any discussion with the TMO about taking up that role, and if so, what it would include?
No, not that I was involved with.
Can we go to ART 406206? This is an email from you dated the 1st of October 2015. And I should just say while we're on this, a lot of the dates from the Artelia side have American dating. So that's a feature, is it?
It
seems to us to be a feature of your email dating.
It is. It's not something that I can influence.
No, it isn't. I'm not asking you about that. Just in terms of how we read the documents. I'm right, am I, in reading this as a 1st of October 2015 document?
Yes, I think so.
Yeah. Yes. Just so that people outside this room need to understand that sometimes that they are in American format. Now, in the first paragraph, you say, for your info, I had a good meeting with Peter Madison this afternoon, and we went through the various concerns regarding quality, programme, cost, etc. He's conscious that his relationship with Steve, that's Steve Blake of Ryden, goes back a long way, and Steve talks to him direct. However, Peter does not want that relationship to circumvent Artelia and bypass the role that we are playing in trying to get the project finished to the required quality and within budget. Peter fully appreciates what we're doing and is very supportive of our approach. Now, you then go on to say something different, but we don't need to look at that at this stage. What I want to ask you is, when you say when you get in getting the project finished to the required quality and within budget, that was really the description of a project management role, wasn't it, there?
That's in terms of the reference there was to the overall project, not to our specific role.
Yes, but in getting the project finished to the required quality and within budget, were you not describing a project management role?
No.
Do you agree that this statement here from Mr. Reid would suggest that Artelia's role wasn't purely an administrative one?
It was to successfully conclude the project.
Yes, that's not just an administrative role. Getting the project finished to quality and on budget isn't administrative or isn't solely administrative, is it? It's project management. Right?
No, we were doing it in an administrative role in accordance with our scope of services. The scope of services asked us to liaise with the professional team in terms of ensuring and managing handover.
Right. Looking at the documents we've looked at, do you think that, or do you accept that it was reasonable for other parties on the project to have the impression that Artelia was acting as a project manager, given that that is how Artelia described itself in the documents we've seen?
Only in those documents we've seen, but on many other occasions we made it quite clear that our role as employer's agent.
Is it possible that no one actually considered themselves to have project management responsibility for this project?
I don't believe so. There are many references to Claire Williams being project manager.
Right. At any rate, your view, I think, as we've got clear, is that you always thought she was the project manager from the start. Is that what you're telling us?
From her introduction to the project, yes.
Right. And you say from her introduction to the project. I wonder if we can be a little bit more specific. Can you time and date that?
I can't remember, no.
Was it at a meeting you were told that?
I can't remember when she was introduced at a meeting.
Right.
I believe she was when I first came across her involvement in the project.
Right. I see. Can we then turn to Artelia's role in providing clarity on roles and responsibilities, which I think is where this topic takes us next?
Can I just ask, I'm sorry to keep interrupting.
No, not at all.
In the period up to the formal signing of Artelia's contract, when we have seen what was undertaken and what wasn't, Can you recall any occasion on which something had to be done by a person in the position of a project manager? And if so, who did it?
I can't, not specifically, no. I mean, during the course of a project, people accept their roles and do their roles, and if they find themselves stepping over or being asked to step over those roles, then they will invariably say so if they're stepping outside of their boundaries. At no time did we feel that we were being asked or drawn into providing a project management service. We felt that the TMO were always in control of that.
So you can't think of an occasion on which you were asked either by the TMO or someone else for that matter to take steps which would normally be carried out by a project manager, and you or someone else at Artelia said that's not our job.
Correct.
Thank you. Sorry.
Thank you, Mr. Chairman. Can I then just go back on a point earlier on? You said, I just want to be clear. The original proposal, the fee proposal, if we can just look at that, at ART 406358, please. This is the 2nd of May 2012, and we can see there is your original fee quote for carrying out the services required at the bottom of the page. And we can see quantity surveying, employer's agent and CDM coordinator. There's nothing there for project manager, it is correct, but there's equally no express exclusion of project manager at that stage. That's right, isn't it?
Not in that letter.
No.
I believe there were obviously attachments to that letter.
No. And then we see what happens later in May 2012 and then into 2013, just to set that in its context. Can we then go to the question of Artelia's role in providing services as employer's agent on this project? ART 405742, please, page 47. This is the schedule of services for the EA role, employer's agent role, which starts at 2 pages earlier on page 45 for those who want to see it. But perhaps we should just flash that up, just so we're clear. Page 45, there it is. 2 pages on at 47, we can see the core services. And if we can look under that heading, there are a number of boxes which have been ticked. 1.1.1 to 1.1.5 have been ticked, as has 1.2.1 and 1.2.6 and 1.2.7, etc. We can see those. If you look at 1.1.1, that's attend client design project site and other meetings, as provided under this appointment. 1.1.2, issue instructions on behalf of the client. 1.1.4, monitoring the performance of professional team and contractor. You see that?
Yes.
And then in the middle of the page in the right-hand column, we can see 1.2.5, advise the client on specialist services, including consultants, contractors, subcontractors, and suppliers required in connection with the project. Now, that isn't marked, it isn't ticked. But below that, again, we see an unticked box, 1.2.8, advise the client on the selection, terms of appointment, and fee structures for the professional team, advise the client on design services required under the building contract. So just taking 1.2.5 and 1.2.8, which were not ticked, what did you understand those services to entail? It's a broad question, I appreciate, but can you give us a sense of what those services, had they been ticked, would have entailed?
In 1.2.5, if it had become apparent that there were a requirement for specialist services that hadn't already been appointed, whether it be in terms of consultants or relative to design or contractors in terms of carrying out the works, that we would be required to advise the client. And
right.
In terms of 1.2.8, advising the client on selection terms of the appointment for the professional team is actually where we would be involved in procuring the team and setting up their appointments.
Do you know why Artelia excluded those services specifically from the core services for an EA?
Because we didn't believe they were relevant to our appointment.
It's a slightly circular answer. Can you just unpack that for us, please. Why did you not think they were relevant to your appointment?
Because the design team was had already been brought on board before our appointment.
Right.
And that it's not uncommon to have those boxes unticked. They are quite specific in terms of roles, and they were not covered within our fee proposal.
Were those services included for the Calc project, do you recall?
I can't remember.
Okay. Was there any discussion internally within Artelia about why you would exclude those services for the Grenfell Tower project?
No.
Were those exclusions ever specifically discussed with the TMO?
It was part of the original offer that we put to the TMO. I prepared the documents and I ticked the boxes as I felt fit in terms of the services that we were offering for the fees that we had offered as well.
Yes, and to answer my question again, having ticked those boxes, as you say you did, was there any discussion ever between you and the TMO about whether they should be included or not included, or why you'd excluded them?
I believe that at some time there would have been a conversation with Jenny Jackson much further down the line after our initial proposal in 2012, which concluded the discussions on what was finally signed.
Right. Did you make it clear, do you remember, to Jenny Jackson or anybody else at the TMO what the consequences would be of Artelia's excluding these particular services, 1.2.5 and 1.2.8, from its scope of EA services?
I didn't feel it was necessary to. The TMO are an educated client in terms of construction contracts and employ consultants on a number of occasions, and are conversant with the scopes of services.
Right. So do we take it from that you assumed that they would understand that what falls within the scope of those services as set out there would not be part of the contract between Artelia and the TMO?
Correct.
Can we then go to ART 405742 for page 48, next page on? This is still within the schedule of services for the EA, employer's agent. And at the top of the page in the left-hand column, you can see clause 1.3.3, which you have ticked or crossed, and that provides establish the roles and responsibilities of the client, the professional team, the contractor, and specialist stroke design subcontractors. What did you understand that service to entail?
It was to identify who was doing what in terms of the people that had been appointed by the TMO.
And how would you expect an employer's agent to go about doing what you've just described? Identifying who was doing what in terms of the people that had been appointed by the TMO, as you put it.
It was identified within the project execution plan, and it would have been covered within the meeting minutes and within discussions within meetings.
Okay, so the project execution plan, and who was responsible for compiling or keeping the project execution plan?
Artelia prepared the project execution plan.
Was that something you had an input into?
Not particularly, no.
Who did?
I believe Alan Dawson did.
Alan Dawson did. So that was the EA's role, was it?
Correct.
I see, I follow. And after Alan Dawson, the others who took on the role of EA within Artelia?
Yes.
I follow. You mentioned Jenny Jackson a moment ago. I think we know who she is, but could you just explain generally who Jenny Jackson is and what you understand or understood her role was?
Jenny Jackson was introduced as the TMO's procurement expert, and she was very much involved in the procurement process that subsequently arose for the contractor, and she was also heavily involved in the discussions and final agreement of our terms of appointment.
Now, just going back to what's on the page in front of us, can you just explain how the role at 1.3.3 to establish the roles and responsibilities of the client, etc., related to the roles at 1.2.5 and 1.2.8, which were excluded, relating to advising the client on specialist services and design services?
So when the 1.3.3 is relation to those people who are actually appointed.
I follow. So I see. So when it comes to establishing the roles and responsibilities of the client, where you had not ticked 1.2.5 and 1.2.8, does that mean that the advice that you gave about that would not include those roles?
Correct.
So would it follow from that where an employer's agent establishes the roles and responsibilities under box 1.3.3, an employer's agent might, in the process of establishing those roles and responsibilities, identify a role or responsibility that was not going to be fulfilled?
There's a possibility, yes.
Yes. And if we go up to the... yes, and in doing so, would have to identify to those who were part of its team, in other words, the client, that there was a gap.
If there was one found to be, yes.
Yes. Now, if we scroll up to the previous page before, page 47, we can see that there's tick box 1.1.3 lies underneath the heading 1.3, Design, RIBA, Outline Plan of Work 2007. Do you see that?
Sorry.
No,
You should be on
can't see
page
it on the screen at the
47.
moment.
No.
Page 47.
Sorry, which number are you looking at?
Well, I'm on page 47, and I'm looking at 1.3, the heading in the bottom right-hand corner.
Yes.
Design, RIBA, Outline Plan of Work 2007.
Yes.
Yes, and my point was that 1.3.3 sits within that section.
Yes.
Yes. And the RIBA Outline Plan of Work 2007 is a reference to the RIBA stages of work.
Correct.
It was later revised, as we know, but that was at that stage. And if you look at 1.2.5 and 1.2.8 again, which, as we now see, are unticked, those items of work or services are in the stage of 1.2 preparation RIBA Outline Plan of Work 2007. Do you see that?
Yes.
So in other words, 1.2.5 and 1.2.8 sit in an earlier stage in the process of the services, don't they?
Yes.
Yes. So that being so, doesn't that tell us that Artelia wouldn't be advising the client on specialist services or appointment fee structures and design services at the preparation stage, but not necessarily at the design stage?
No, because these services, although they are identified within particular stages, they are not necessarily exclusive to those stages. And I think that's stated at the top of the course, just above core services.
Where would you be identifying that?
There's if you scroll to the top of the page, please.
Yes. Are you referring to item 3?
There's so item 5.
Item 5. I see what you're saying. Yeah, that's in practice. Many of the services will be carried out in more than one section. That's where you do tick. But where you don't tick, as we've seen in respect to 1.2.5 and 1.2.8, the absence of those services from the EA scope at the preparation stage, according to the RIBA 2007 outline plan, wouldn't necessarily mean that they fell out of the scope of the works altogether if they came back in through another provision at a later stage, such as design.
No, I don't agree with that. If they're not ticked, they're not ticked, and it means that they are excluded completely. That's my understanding.
Let me put a proposition to you then. But if by the design stage, next stage on, Artelia has to establish the roles and responsibilities of the client and the professional team, does that not bring with it an obligation to advise the client on specialist services or design services, if in fact they're missing at that stage?
No, because I believe that responsibility would sit with others.
Who would it sit with?
That would sit with the members of the professional team, or it may even sit with the TMO.
Right, and members of the professional team for this purpose being?
Studio E, Curtains and Max Fordham.
As you defined yesterday, you say it may also sit with the TM, may even sit with the TMO. Isn't that precisely the point? that under 1.3.3, by that stage, in the design stage, it was Artelia's role to identify precisely who had what obligation, so that if it was the TMO's obligation to take advice about specialist services or design, it was Artelia's job to tell them that.
In terms of the roles and responsibilities
Yeah.
of who had been appointed, not in terms of who had not been appointed. If there was a gap between that, then we would look to close the gap between. The idea is to make sure there was no gaps between those that have been appointed,
Exactly.
or that the fact there may actually even be an overlap, which sometimes is the case.
Indeed. I think you're accepting my point, which is that if you'd spotted a gap in the course of performing your services at the design stage under section 1.3.3, you would tell the client.
Yes, because we're expected to make it quite clear that everybody understands what they're supposed to do as part of their roles.
Indeed. Can I then move to a different topic, which is client design advisor, CDA? It's right, I think, that Artelia acted as CDA for the Calc project.
Correct.
And can we go then to ART 408591, please? This is an email from Phil Booth to you, Mr. Cash, on the 10th of January 2014. Again, American dating. And it says, Simon, Claire wishes for us to put forward a proposal for the CDA role. As the custodian of fee proposals and scopes, please can I ask you to do this? I know they are considering others, e.g. one-man bands, but they have PI concerns. And PI, just for the benefit of others, perhaps, is professional indemnity. Is that right?
Correct.
Yeah. And by way of context, it's right, I think, that this email was sent during the OJEU process, the OJEU tendering process, before Ryden was appointed as a main contractor.
Yes.
Yes. So is it right that Artelia was considering itself at this stage as a possible candidate for the CDA role at this time?
Yes.
Yes. Turning then to what the role of the CDA involves, and I want to look first at the services. Can we go, please, to ART 406279? This is a proposal for CDA dated February 2014, as you can see. Do you recognise this document, Mr. Cash?
Yes, I do.
You do. Did you personally approve it or have any input into it?
No, I didn't.
You didn't. Do you know who did personally approve it?
I can't remember.
Because it's a proposal. Would it have been someone within the Grenfell Tower project at that stage?
No. The CDA role is performed by another team within Artelia.
Right.
And it would have been prepared by Rich Mulharding, who would have been the person nominated as the CDA, and she would have had the proposal signed off by her line manager, and then it would have been passed to me for final issue.
I think you've answered a series of questions in that answer that I had, but it was you say it would have been passed to me for final issue. So you were the person who would have issued it to the client.
Correct.
And in doing that, would I be right in thinking that you would have taken steps to read it at least?
I would have looked through it. I wouldn't have read every detail of it.
All right. Now, just pursuing that a little bit, can we go to your witness statement, your first witness statement at page 48? And I want to look at paragraph 48 if we can. I'm sorry, paragraph 148 on page 48. And you refer to this proposal. You say, on the 4th of February 2014, Rich Mulharding at AUK prepared a draft proposal to act as client design advisor for the TMO on the project. I sent this proposal to the TMO on the 27th of February 2014 by post and 28th of February 2014 by email as part of a revised fee proposal. As I explained later, the TMO declined to accept the proposal for AUK to act as client design advisor. Had the TMO taken up this offer, the client design advisor role would have been provided by Rich Mulharding, an architect who worked in a different part of AUK's business. Now, you put some dates in there about when when it was prepared and when it was sent. If we look at the proposal itself, going back to it, ART 406279, please. Can we go to page 18? You referred to Rich Mulharding as the person who prepared it. There is her CV. And we can see in the bold text at the top that she is a qualified architect, yes?
Yes.
And and we can see elsewhere, I think, she'd passed the RIBA Part 3 in 1993. We get that on the left-hand side of this document under qualifications. Do you see second entry down?
Yes.
Yes. And then under relevant skills and experience, which is a large box halfway down the page, it says, 5 lines down, her move, do you see that? Her move into the PFI PPP sector 3 years ago has seen her focus on major high-profile public capital expenditure programs where she is responsible for contract due diligence and scrutinising project delivery to ensure compliance with all necessary British and European standards, output specifications, funder requirements and statutory duties. She is rigorous in her approach and highly valued by our funder and authority clients for protecting their interests on these complex schemes. So just on that, would you say that Ms. Harding had very specialised training, skills and experience, particularly in design?
Yes.
And I think at this time she was an architect of some 15 years' experience.
Yes.
Yes. And if you look at the box, the relevant experience halfway down, which I referred to a minute ago but didn't go to, there's a table called relevant experience, and at the top entry you can see that she was Client Design Advisor, CDA, for the Kensington Academy and Leisure Centre, CALC, for RBKC, wasn't she?
Correct.
As you said before. And if we go to page 3 of this document, you could see the services that Ms. Harding would perform if she were appointed CDA.
Yes.
And they're set out in the big box at the bottom. I'm not going to read them all out, but if you look at the third bullet point, can we just do that? She would, if appointed, review through a design compliance report agreed key design packages following the production of detailed drawing stage F, reporting to KCTMO using our risk-based warning light methodology backed up by our firm opinions and recommendations. What would that entail in a bit more detail? Do you know?
Yes, this would be looking at the contractors' proposals and designs when they were preparing construction drawings or manufacture drawings and reviewing them against the employer's requirements to see if there were any derogations, and then using what we call a traffic light system of red, amber and green as to whether those derogations were acceptable, need consideration, or were unacceptable in terms of what the TMO had identified in terms of their employer's requirements.
Right. Just examining that answer a bit more, can you just help me? Would that service or set of services that you've just explained there include comparing drawings with the NBS specification?
Could do, yes.
Would it involve monitoring the development or evolution of the drawings to make sure that they did include what was in the NBS specification?
I don't believe it would be monitoring the evolution of the drawings. It would be looking at the drawings that were finally issued once they'd been completed.
And taking that into account, comparing those with the NBS specification?
And whatever information is in the employer's requirements, correct.
Yes, and would that also include checking for regulatory or statutory compliance?
It would look at the question of regulatory compliance.
Yeah. Would it include looking at the as-built drawings?
Yes.
And making sure that the as-built drawings conformed precisely with what was actually on the building as built?
Part of the role is site inspections and looking at compliance.
Right. And would that include also examining any changes in materials from the NBS specification to new materials?
If they were part of a variation or a contractor's proposal, yes.
Yes. If you go to page 6 of this document, you can see scheme design just below halfway down the page. And it said that we will provide a design compliance report at pre-contract award stage following a review of the construction or contractor's proposal, CPs, and endeavour to ensure that they meet the employer's requirements, ERs, NBS specifications, British and European standards, as well as all statutory and planning requirements. Once the contract is let, we will review detailed drawings as they are produced to ensure the works proposed continue to meet ERs. We will provide design advice as required by the KCTMO. So just pausing there, in fact, I think the services that she was offering or were being offered as part of this would include reviewing detailed drawings as they were produced, not just at the end.
Yes, sorry, when you say it wouldn't be the evolution of the drawings until they were produced. So drawings are issued in various stages.
I follow that. Okay, so when as they are produced, you mean conforming to each stage under the RIBA scheme of work?
Correct, but at this stage they will be stage F.
Yes. So we'll just explain then what you meant, or what was meant by Artelia by the expression as they are produced.
Yes.
But what does that mean?
That as drawings are completed, they are issued in batches because they wouldn't necessarily issue every single drawing all at once.
Right.
So they would be concentrating on elements of design to suit their construction programme.
I see.
And that they would then issue them in batches.
I see. So just help me. So if a cladding subcontractor such as, for example, Harley, issued a revised drawing to Studio E through Ryden, would that be something that would be a drawing as produced, which would then be reviewed by this scope, picked up by this scope of services?
No, not necessarily, because we wouldn't know that that drawing had been issued to Studio E. It would be drawings that are issued by Rydens to the client team for comment. So, as acting as client design advisor, effectively looking at the drawings that are issued by Rydens, not by Rydens' supply chain.
I see. But so I think you're telling us that you would be dependent, or Artelia in this role would be dependent on Ryden issuing drawings to the TMO as the client. Is that
Correct.
right?
And in the event that this role had been taken up, the drawings would have been issued to us as well.
I follow. Looking at page, stay on this page for the moment. Would the check to ensure that the works continue to meet the ERs, would that involve a check whether the design proposals met the initial Studio E design as set out in the ERs?
Yes.
Yes. And I take it that would also include checking for compliance with British and European standards and statutory requirements.
In terms of the designs that are issued by Rydens, yes.
Yes.
It's not for us to check that Studio E's initial design is compliant. That is part of Studio E's role.
I understand that. And that is part of the check for compliance. That would include the building regulations, I assume, would it?
Yes.
Yeah. And would that review also include whether the employer's requirements themselves were compliant with the British and European standards, including the building regulations?
No, because that's
So that's part of Studio E?
Correct.
I see.
And Curtains and Max Fordham as well.
Right. And what would be recorded or included in a design compliance report?
I can't say specifically, but it would certainly look at things like any derogations between the contractor's proposals and the employer's requirements. And as I said, it would also include the traffic light risk review in terms of the impact of those derogations. It would look at any compliance. It would look at planning, whether there are any particular planning issues that may still need to be addressed, where they're not fully addressed by the current designs that have been issued.
Yeah. If we go to page 6 at the bottom, at the end of the scheme design section, it says, as I've shown you, we will provide design advice. What would that design advice have included had this role been taken up by Artelia?
It would have been design advice as required by the TMO. If the TMO had asked us for our opinions, then we would have given it. It wasn't anything in terms of saying that we would provide a continual design advice service in anything in a general aspect.
Right. But would it include Artelia identifying non-compliances if they were reasonably obvious from the drawings with which you had been provided?
That would be part of the compliance role, yes.
I follow. Right. And the CDA appointment would continue, wouldn't it, after practical completion, I think?
Yes.
So that if the design changed as a result of value engineering, the CDA would review the resulting design for compliance with relevant statutory requirements.
Correct.
Yes. And equally, if the design changed for any reason during the build, I think you would also expect the CDA under this proposal at least, to review all the decisions taken to make sure that there was compliance with all relevant statutory requirements.
If it's identified as a change, or if there are revised contractors' proposals that are issued.
Yeah. So, standing back, would I be right in thinking that effectively the CDA's role under this proposal would involve a check for design compliance throughout the lifetime of the building contract?
Correct.
Yes. Would it be normal to have a CDA appointed at this point in the process? In other words, after the employer's requirements had been established and the tender process was well underway?
It's not uncommon. It's a role that quite is in various terms required when the design team is novated and the client actually doesn't have anybody left to advise them on technical matters.
I see. Was there any consideration of having a CDA appointed at any earlier stage in the project? For example, at the very start of the tender process in or from June 2013?
I can't remember if it had been discussed in particular detail or
I
not.
can't remember. Would it be good practice, or would it have been good practice at the time, to the best of your understanding of thought processes at the time, to have had a CDA on a project like Grenfell?
At the time being the appointment of the contractor?
Yes, from the early part of 2014, say, if not earlier.
It would have been appropriate once the contractor was on board.
Yes. I mean, we've got a refurbishment here of a high-rise residential building with an overclad, where the budget was around about, for the sake of argument at the moment, £9 million. In a project of that scale and complexity, was your thinking at the time that it would have been a good idea to have a CDA?
Yes, on the basis that the design team, members of the design team were being novated.
Right. Can I ask you to look at page 11, just to see the fee proposal for the services that were being offered? You can see there that the fees for the CDA role were a total fee of £30,922. That's right. That's an all-inclusive role, is it?
Correct.
All-inclusive price, I should say.
Yes.
Yes, I see. With the £600 for post-occupancy evaluation. I follow.
That was an optional extra that was offered.
Right.
So the CDA role as offered in the proposal was the first line. The second one was an option if they wished to take that up.
Do you know how that fee was arrived at in general terms?
I believe it was looked at in terms of initial review and then a monthly calculation.
I follow. And would that be, can you give us an idea of whether that's a high fee or a low fee, or whether you were giving the client a good rate?
I believe it's a fair fee.
Right. I'm sure you'd say that. I wonder whether there was any way we could compare that with anything else.
We do a number of CDA role fee proposals. I don't get involved in them very often, but I didn't see it was an unreasonable fee.
Right. Thank you. Mr. Chairman, we are at the sort of middle of this topic, but I'm going to move on to a different subtopic, I think.
Would that be a good point?
Yes, it's good. Thank you.
Yes. I think we should all have a short break at this point, Mr. Cash. So I'm going to ask you to go off with the usher in a minute. We'll come back at 20 to 12, please.
Yep.
And as I said yesterday, please don't talk to anyone about your evidence or anything to do with it while you're out of the room.
I won't.
Good. Thank you very much.
Thank you.
Go with the usher then, please.
Thank you.
20 to 12 then, please. Thank you. Good. Would you ask Mr. Cash to come back in, please? All right, Mr. Cash, ready
Yes.
to carry on?
Thank you.
Mr. Chairman, thank you. Can we now go to page 4 of this same document, ART 406279? And I'd like to look with you, please, Mr. Cash, at paragraph 2.1 on that page, under the heading Project Understanding and Key Data. And in the second paragraph there, we can see that it says, with the novation of Architects Studio E to the contractor, the relationship and direct access to architects and other members of the design team that you have enjoyed on this project to date will change. The services of a client design advisor will ensure that the initial design that you have agreed and promoted to stakeholders does not get watered down as part of the procurement and delivery process. Now, you've explained, I think, in your third witness statement what the purpose is of engaging a CDA. And I just want to show you that. If we go to that, please. Third statement, page 16. At paragraph 36, you explain there that the core purpose of a CDA and similar appointments is to ensure that the interests of the employer, here the TMO, are protected throughout scheme design, to ensure that the design is not watered down during ongoing scheme design and construction. Just pausing there, what does watered down mean?
It's referring to whether or not the contractor, the design and build contractor, will try and make some substitution in terms of their proposals that is to a lesser standard or to a lesser quality than the employer is requiring, or to a lesser, it could be capacity or performance. Generally, it's basically there to protect the client to ensure that they are getting what they've paid for.
Right. Just continuing then with your paragraph. A CDA seeks to protect the employer on a design and build contract who will, as a consequence of the novation of the architect to the design and build contractor, have lost the services of an architect. On the project, as Max Fordham, the M&E contractor, was not to be novated to Ryden, M&E services on the project were not to be addressed by the CDA. The CDA provides advice as required by the client and reviews drawings to ensure that what is proposed continues to meet what is set out in the employer's requirements. In your recollection, how important was it to you at the time that the TMO had that sort of advice on this project?
It's important that somebody has the responsibility of commenting on the designs that are being put forward.
So, who was that in the end?
It's Claire Williams.
She was the client, though.
Yes, but it doesn't mean to say the client is an educated client, then there's no reason why the client can't take that role on themselves. It's I've seen it done before.
So when you say important that somebody has the responsibility of commenting on the designs, who would that person be commenting to?
It could be an external consultant commenting to the client, or it could be the client doing the checking themselves.
So the client would comment to themselves? Is that
Correct,
right?
yes.
Right. Okay. Did you think that there was a particular risk in this contract that would mean that the client, the TMO, would benefit from a CDA?
We had proposed the service because we felt that there was a need for somebody to have a responsibility for commenting on the contractor's proposals. At the end of the day, the client took that role on themselves.
Yes. Just to unpack that a little bit, you say you felt there was a need for somebody to have a responsibility for commenting on the contractor's proposals. But do you mean by that answer, just to press you a bit, that you thought that this project required somebody to advise Claire Williams on the contractor's proposals?
No, I was purely saying that we could provide a service. I didn't say that the client had to have that service.
No, I'm not suggesting that. Let me try it a slightly different way. You were saying that you could provide a service. Did you think at the time that the client needed that service?
We didn't know that they needed it. We said we offered it as an option. Clients may have the expertise and may not still wish to carry out that. They may wish to devolve that responsibility. in the same way as the employer's agent could equally have been within the client team.
Yes, but you said earlier on, line 3 on the previous page of the transcript, that you'd proposed the service because we felt that there was a need for somebody to have a responsibility for commenting on the contractor's proposals, and that's why you proposed the CDA.
Yes.
What I'm really trying to tease out from you is whether, when you said you felt there was a need for somebody to have a responsibility for commenting on the contractor's proposals, was that because you didn't think that the TMO had their own expertise to carry that responsibility for themselves?
It wasn't clear that they had.
It wasn't clear that they had. Did you ever spell out the risks to the TMO so that they, whether it was Claire Williams or Peter Madison or anybody else at the TMO, that they fully understood the consequences of not having a CDA and what it was that they would have to take on in order to avoid things like, as you put it, the watering down of the ongoing scheme design and construction?
Yes, I believe that we had conversations regarding that, which led to the request for providing a CDA service.
I see. So there were conversations, were there, that led up to them asking you to provide that service, as we saw in the email?
Yes.
Hence the reference to one-man bands.
Yes.
Were there... Well, we'll come on to this now. Can we then go to ART 402701? Because we can see what happens to this proposal. This is an email from the TMO to Philip Booth. Now, he was, I think, the employer's agent at this point, wasn't he?
Yes.
And it's also sent to Peter Blythe, who was assisting him in that role. Yes?
Yes.
Yeah. It's dated the 29th of August 2014, but it says, Dear both, last Tuesday we talked about the appointment of a design advisor and the likelihood that this did not particularly apply to cladding and the M&E elements which were designed and under guarantee. And then in the next paragraph, she says, I've spoken to David Gibson and we're going to see if we can manage this within the TMO, as we are very familiar with the specifications for social housing. We will monitor how this is working, as presumably all proposals for comment will have a respond by date. Can you please send any design proposals to myself, CC David Gibson? Now, just pausing there, last Tuesday, I think, refers to a meeting on the 19th of August, which I don't think you were at, were you?
I can't remember.
Right. Do you know why it took from the 27th of February 2014, which is when you sent the CDA proposal dated the 4th of February 2014 to the TMO, for the TMO to decide whether to appoint a CDA? Can you explain the gap?
No, I can't.
Did you or anybody else at Artelia, to the best of your recollection, prompt the TMO for a decision on the appointment of a CDA between February and August of 2014?
I can't remember specifically, no.
Did you agree in your own mind with what Claire Williams was saying, that a CDA was unlikely to be necessary in circumstances where the cladding and the M&E elements were designed and under guarantee?
No, I don't agree with that.
Did you or Phil Booth express your disagreement with her about that?
I wasn't aware of this particular email until it's been disclosed.
To the best of your recollection, did Phil Booth go to her and say, well, you're wrong about this?
I don't know.
Right. Let's just see what Ms. Williams says about this. This is a statement that she produced to the inquiry in January of this year, 2020. It's TMO 20863359. That's its first page. And I'd like to go to page 7, please, paragraph 30. And she says there, Artelia explained to me that the CDA role would not touch on those discrete areas of the project where specialist contractors would have specialist knowledge about their design and the materials used that Artelia would not have. This is what I meant in my email to Peter Blythe and Philip Booth, where I said, and she quotes the part of the email I've read to you about not applying to cladding and the M&E elements. Were you aware? Well, can you help? Did Artelia ever tell Claire Williams, to the best of your knowledge, that the CDA role would not touch on those discrete areas of the project?
No, I don't believe so. I don't recall.
Is that is what she says there correct, so far as your understanding of what a CDA would do if appointed under the terms of the proposal?
No, the roles were quite clearly stated within the proposal that was sent to her.
Right.
But it covered the whole of the design.
It would cover the whole of the design. So she was wrong in her understanding. Did you talk to Claire Williams or Peter Madison at all about the CDA proposal between February and August 2014?
I can't remember.
Right. Did she ever tell you, or did he ever tell you, no, we don't want it in respect to the cladding? Or was this email the first you've seen of it?
This is the first I've seen of it.
I see. Would a CDA, a client design advisor, normally only focus on the areas with greatest design concerns, such as, for example, the new build areas that she's referred to in her email?
No.
So a CDA would look at every aspect of design, would they?
Correct.
Yes. Can we go back to the email then again? It's ART 402701. She says in the second paragraph, I've spoken to David Gibson, etc., and I've shown you that. Just look at it again. If we go to ART 406464 at page 2, please, we do see that you were actually forwarded this email by Philip Booth. You see that?
Yes.
And that's on the 29th of August, 2014, where he says to you, among others, Richmond Harding and Robert Marr, sadly, TMO decided to be their own CDA. So it does look, Mr. Cash, as if you did see this at the time. Do you remember seeing that at the time?
Yes, I do.
And if you'd seen it at the time, you would have seen that she was wrong in her understanding. Having seen that, can I ask you why you didn't go back yourself to the client, or tell Mr. Booth to go back to the client to tell her that she'd misunderstood the role of a CDA, and the role of CDA was not to be excluded in relation to the cladding and the M&E elements?
I don't know.
Did you have any thoughts at all about her reasoning behind her declining of your proposal?
Only that, obviously, as an educated client, that they had the capacity to provide that role themselves.
Right. Well, let's just move on a little bit, as I think we do see something. We can see on page 1 of this email run, there's an email from you to Phil Booth on the 1st of September 2014. So a couple of days later, after he sends you her email, in which he says, sadly, TMO decided to be their own CDA. And you say, Philip, I'd like to think that with Ryden's approach so far, it should not be an onerous task. However, it is very important that we do not find ourselves being dragged into dealing with any issues relating to compliance or design advice without it being acknowledged as additional work. You refer to Ryden's approach so far. What did you mean by that?
That they had been very cooperative and had been issuing a lot of information, and that there was no reason to think that in terms of what they've been doing so far that there would be any issues of them derogating from the employer's requirements in terms of what information they might provide.
I follow. Did you understand that Ryden at that time would be looking in their approach so far, as you put it, at design compliance of design with regulatory requirements?
Yes, because that's part of their role as a design and build contractor.
Yes. And when you say should not be an onerous task, did you mean onerous for the TMO or for Artelia?
Onerous for the TMO.
Right. Does that mean that your understanding at the time was that the TMO could rely on Ryden's design skills as demonstrated by its, quotes, approach so far, unquotes?
When you say rely, do you mean in terms of not checking it, or do you mean in terms of it being correct?
I think both is what I probably mean. What do you think?
I think it's. I would think it would. I don't think it'd be right to rely on it. I think you still have to check it.
Right. So to check it, you would need. Well, what sort of skills or qualifications would you need to check Ryden's work, which would include Ryden's assessment of design compliance?
Need to understand design.
You need to understand design. What does that mean? Could you just
You
give
need
us
to
a
have
bit
a
more?
knowledge of design and the regulations and what is compliant design.
Had you taken any steps to satisfy yourself that your client had knowledge of design and the regulations and what is compliant design?
No, I was satisfied that they said that they had the expertise in-house.
Right. So you took them at their word.
Yes.
I'm not saying there's anything wrong with that, but you never explored further whether or not, in fact, the client actually had the skills to carry out the role they were taking on.
It wasn't for me to do that.
Turning to Ryden, had you taken any steps to satisfy yourself that Ryden would analyse the designs and check compliance?
They had been through a procurement process that had reviewed their technical competence as well as their experience of carrying out refurbishment projects, and that everybody was satisfied that they would be able to provide a design and do that with the novated design team of Studio E.
I see. Did that procurement process, when you say reviewed their technical competence, we'll come to the procurement later in your evidence, but just for present purposes, can you identify with any precision what it was in the procurement process that led you to think that Ryden, as opposed to outsourcing it to others, Ryden had expertise and technical competence in the matters of design?
You wouldn't necessarily have they wouldn't necessarily have to have internally expertise in design, because they were engaging other people to carry out design as part of their team.
At this stage, they would propose to have other people to carry out design, but at the stage of the tender process, those people hadn't yet been appointed. So, repeating my question, what steps did you take to satisfy yourself that Ryden had the technical expertise to carry out the design and provide suitable design advice itself to the TMO?
We knew that Studio E were going to be novated to them, and we knew that and part of the tender process was identifying whether or not they would be carrying out those design services in-house or be using their supply chain.
I see. But you didn't know who was going to be in the supply chain?
Not necessarily. I wasn't part of the tender process.
No, indeed. So you wouldn't actually know who, in fact, it was at the bottom of the chain who was actually going to be providing the designs?
Correct.
Did that mean that you couldn't actually do any proper analysis about whether Ryden had the skills itself to know whether those designs were compliant?
Only in terms of looking at the CVs of the people that were proposed within the tender that was submitted and their ability to manage design.
Indeed. Was it not Artelia's role as employer's agent to make sure that Ryden had itself the relevant skills to be able to supervise the design and compliance activities of its subcontractors?
As part of the tender process, that was one of the evaluation criteria.
Yeah, indeed. So I think the answer to my question is yes.
In conjunction with the TMO, who were also one of the evaluators as well.
Right. In conjunction with the TMO, who were also one of the evaluators as well. And again, the reliability or effectiveness of their evaluation would depend on their own qualifications, skills, and experience.
Correct.
Yes. And did you take? I think I've asked you this before, but in that connection, let me just ask it one more time. And I'm sorry if this is repetition of a question. Did you yourself, or to your knowledge, anybody at Artelia, take any steps, actually rigorously, to make sure that your client did have the relevant experience, expertise, and qualifications to understand what it was that Ryden were doing?
No, I didn't think that was part of our role.
Right, didn't think it was part of your role. Can we go to your first witness statement, page 55, please? I want to look at paragraph 173. 29th of August, you say, Claire Williams, the TMO, responded, and you've set out the contents of the email there. And in the last sentence, you say, while I was disappointed that AUK was not appointed, I thought that the TMO, as an organisation that managed a lot of properties in the RBKC, had the necessary experience to carry out this role. Why was managing a lot of properties in RBKC relevant to whether a CDA is required or was required?
In terms of their understanding of specifications and compliance, I would have assumed that they would have had a good knowledge of what those were, and that they have the expertise, they have their own internal project managers, they have their own health and safety, internal health and safety, that they were felt competent to be able to carry out that role.
Well, be a bit more specific. You've identified managing a lot of properties. Can I just ask you why? Managing properties that doesn't include understanding design and compliance of design or materials with regulations and statutory obligations, does it?
No, but in looking after properties and also constructing new properties, they were involved in capital works, which would have to have been regulatory compliant in terms of regulatory standards.
Right. I mean, put it a different way, did you think that the skills which the TMO's team on this project had were comparable with the design analysis skills of someone like Richmond Harding?
I can't really comment on that.
Well, I'm asking.
I don't know what their qualifications were.
No, indeed. So when you're comparing like with like, I think I'm getting the sense from you that you didn't actually put Richmond Harding as the potential CDA on one side with her skills and experience, and ask yourself, well, does the TMO have the same skill set and experience set as Richmond?
It wasn't in my remit to do that.
Did you ever give any thought, generally, to the TMO's ability to perform the CDA role during the Grenfell project?
No, I felt that occasionally they were asking us questions which they should have been dealing with themselves, and we put them back to them.
Right. I mean, to your knowledge, I think you're telling us that Claire Williams and David Gibson were never told that they didn't have the skills of somebody like Richmond Harding who would be able to carry out a CDA role as per the proposal.
Correct.
Right. And do we take it that by their decision you just assumed that they would have those skills without investigating it any further?
Yes, we made a commercial offer which they turned down.
Now, are you aware of any response back to the TMO to Claire Williams' email of the 29th of August that we've just looked at, where she says we don't want to take on the CDA role? We don't want to appoint a CDA.
No, I'm not aware of any.
No. We haven't been able to find one. Do you know why there was no response?
We took it as read that they'd made their decision.
During the project, did Artelia ever consider telling the TMO, even informally, that they ought to reconsider that decision?
No, not that I remember.
Going back to the question a moment ago of the TMO's ability, I think you've told us that you never did any specific investigations as to Ms. Williams' technical qualifications. Just to confirm that, that's correct, isn't it?
Yes.
Yes. Nor indeed Mr. Gibson, is that right?
Correct.
Nor Mr. Madison, or in fact anybody at the TMO you dealt with?
Correct.
Yes. Was it your impression that Claire Williams was taking decisions, design decisions, I should say, specifically, herself?
I believe that she was, yes.
Did you think that at any time she might have been referring design decisions to others at the TMO?
I don't know.
You don't. Can we look at ART 406480, please? This is an email chain, October 2014, 29th of October 2014 at the top, and it relates to an incident where the boilers were turned off, allegedly because of Ryden's works. That's the background to it. I don't want to go into the detail of that, but can we go to page 2 of this document? And look at the bottom half of that second page there. This is an email of the 29th of October 2014 to you, Mr. Cash, from David Gibson of the TMO. And he says, Simon, since sending this below this morning, Peter Madison has been in touch. He's actually on leave, returning Friday. He's requesting that you lead on review of arrangements. We need clarity between Ryden, Artelia, including your CDMC responsibilities, and Max Fordham on how designs and method statements are agreed and signed off before works commence. And scrolling up to the top of the page, you say, Mr. Gibson says back to you. In fact, we can't see that on this page. Perhaps we should just have at the bottom of page 1. Because we can see this comes to you as the primary recipient of this email. And then if we can flip back to page 2, I'm sorry that these have been split over the page. You can see he says to you, Mr. Gibson does, I still need an overall view on design sign-off, etc. I have yet to establish who will lead on this. And then if we go to the first page of this email chain, we can see what you say in response to this email internally, I think, to Nick Valente, same day, 29th of October. And you say, this really needs to be discussed with Philip, that's Philip Booth, I think, when he's back from leave. We offered the TMO client design advisor services, and they declined, saying that they would do this role themselves. So I do not see that we have a role in any sign-offs. We will obviously need to write to the TMO with chapter and verse, but if Keith can respond in the meantime, that will hopefully allow us time to look at the wider detail early next week. Now, by sign-offs that you refer to there, do you mean sign-offs on a design change?
Correct, and commenting on designs.
And commenting on designs. Would a CDA have a role in sign-offs that you refer to there?
Not in sign-offs. The CDA would advise on compliance. It is still with somebody. It would be with the TMO to provide the ultimate comments. But
right.
The CDA would provide the feedback to the TMO.
Yes.
To allow them to make the comments.
I see. Was it your impression at this time, late October 14, that the TMO might have been confused about who was meant to be having input into the designs and method statements before the works began on site?
It is not uncommon for people to misconstrue who is doing what, and sometimes you have to reiterate what the roles are.
Yes. And you say we will obviously need to write to the TMO with chapter and verse. Could you just explain what you meant by that?
That was in relation to the incident that had happened and who was responsible for ensuring that that particular work, because it was in relation to actually work, not design, there was the incident, and signing off and approving the work carrying out because it interfaced with existing systems that were outside of the contract.
Right. Was it your understanding at the time that perhaps Claire Williams was confused about precisely what Artelia's role was in respect of design and particularly sign-off?
I don't believe necessarily Claire Williams, but obviously Peter Madison had raised the issue, and David Gibson was forwarding on Peter Madison's views.
Very, very well. Then I ask the same question again in respect of David Gibson and Peter Madison. Do you think they might have been confused as to precisely what Artelia's role was in respect of design and sign-off?
I think I don't know whether it was in relation to design, because this is in terms of, as I say, a physical incident which happened on site, and it was one that was quite significant in terms of stopping heating, go to the, I believe, or hot water to the residents, and therefore I believe that the email was very much a knee-jerk reaction in terms of trying to get people to do something.
Yes. Can we go to ART 406658, please? This is an email chain from August 2015, so 10 months later or so. This is also about the design of the boxing club and savings made because of emissions. And if we go to page 3 of this is an email from Claire Williams to Neil Reed, copying you and others in. You can see that at the bottom there, 17th of August 2015. Neil, thanks for your resume. I thought it would give you some time before I rung, but it sounds like you're pretty up to date. I'll catch up with you. And then if you go to page 4, you can read her email. If you go to page 4, this is starts with an email from Neil Reed to Claire Williams after a site visit he'd made that day. And there are various points of detail in there. And then her email back, if you go to the bottom of page 3, we can see where it starts. This is to Neil Reed, but it's copied to you, Mr. Cash, same day. Thanks for your resume. And then over the page, at the top of page 4, she says, in the third paragraph, that she's established that the tiling in the boxing club is not as specified. So she asks for a hard copy of the spec, and she's asked Tweechin about the finishes costed for the boxing club, etc., and there's something about the shower rooms being plastered and painted, etc. And then one minor bit of good news about blinds. These are just details, but I want to show you page 1 now. That's the context. She seems to be asking Artelia to check the specification to see if certain items are included. And if you go to page 1, which is what I really want to ask you about, this is Neil Reed's email to you, the 18th of August 2015. And it responds to your email to him of the same day. And that is where you say to him, Claire may think that it is our job to check what the specification requirements are against the contractor's proposals. However, compliance is not part of our role. In terms of what is and is not included in the tender, as quantity surveyors, we prepare a contract sum analysis that breaks down a lump sum tender offer from the contractor to give us something that allows proper evaluation of tenders and something against which to manage costs during construction. It's not a definitive document, and the only way of telling what is and is not included in the contract is to check the employer's requirements and the contractor's proposals. This is not a QS or PM role, but rather one that relates to the CDA services that we offered and was declined. Can you explain there what you meant by compliance when you say compliance is not part of our role in the first paragraph?
It's in relation to the compliance of the contractor's proposals against the employer's requirements.
Right. And what about compliance of the work done with the contractually agreed specification? Same.
Same.
Right. Would you agree with me that this email exchange demonstrates that the TMO, even at this stage, so August 15, wasn't clear about the role which Artelia was performing?
I didn't say that it demonstrates that they're not clear. I just think it demonstrates that Claire is trying to get us to do something that's outside of our scope.
Knowingly?
Could well be.
Well, you say could well be. I mean, there are two possibilities. Either she was confused about your scope, or she knew very well what your scope was and was trying to get you to do something outside it. What was your impression?
That she was trying to get us to do something that was outside of our scope.
Right. Do you know whether you or anybody else at Artelia did anything in response to this?
I can't remember.
It's clear from Mr. Reed's message back to you, as I've shown you but not read to you. He says this is very helpful. Top of the page. As and when you do speak to Peter, that's Peter Madison, I think it would be helpful if you could run through this with him as we continue to come under pressure, even today, to provide clarifications about the spec and attend meetings. Thanks. And again, was your understanding that the pressure was to do something you weren't contracted to do, or that there was confusion?
It was that we were being asked to do something we weren't contracted to do.
Do you know whether Mr. Reed ever did speak to Peter Madison to say, look, stop trying to get us to do something that's out of scope?
I don't know whether he had a conversation with Peter Madison or with anybody else within the TMO.
Well, let's move forward in time. Can we go to ART 406656, please? This is an email chain in September 2015, and it concerns an issue between the TMO and Ryden about the performance of lifts in the event of a fire and the effects of the fire alarms. And there's a long email which Simon Lawrence sends to Claire Williams, and that's on page 2. He sends it on the 11th of September, as we can see there, and it goes over to page 3. If we just look at that email, the first part of it on page 2 is all about the fire panel and various details about that piece of equipment. And then if we go to the second page, at the top, we can see an email from Claire Williams to Neil Reed and Andrew Malcolm, Grenfell lift. Chaps, can you please give me a ring with your views on this and where we go with it? There seems to be a couple of anomalies. I mean, if we go back to the first page, we can see that Mr. Reed then forwards this email on to you on the same day. And he says to you, I'll call you after lunch to discuss. 1, the challenges go on, lack of design coordination and foresight. 2, Claire is emailing us and seeking to draw us in on conversations about 1, exclamation mark. I remain concerned about time we're spending, along with the very fact these things are coming up at this stage in the project. Did you agree with Mr. Reed that there was at this stage a lack of design coordination and foresight?
I believe that was in relation to design coordination with interface with existing systems.
Well, he says the challenges go on. It looks as if Mr. Reed there is expressing the view that this is a general problem. In other words, that there is a general problem about lack of design coordination and foresight. Is that right?
I don't know whether it was in general terms, but I know in terms of in terms of what he was responding to, the issue raised by Simon Lawrence was in relation to interfaces with existing systems.
Right. I'm really just seeking to get to the bottom of what you really understood by this message. Did you understand him to mean that this was specifically related to the interface with the existing systems or a more general problem?
Interface with existing systems.
Right. And is it right that the TMO was trying to draw Artelia in to assisting on or resolving design and coordination problems?
It appeared to be from the fact that Claire Williams was asking for our views, yes.
Right. Is it fair to say that Claire Williams was trying to rely on Artelia for design decisions at times during this project, which Artelia did not regard its role as
Correct.
including? Right. I've covered this a moment ago, but I think you're telling us that you thought that Ms. Williams knew jolly well that that was outside the scope, but we're trying to get you to include it.
Yes.
Did you ever say to her, in terms, look, Claire, this is outside scope, stop trying to expand the scope beyond what we're responsible for?
I believe that there were a number of occasions when not necessarily myself, but other members of the team responded to Claire saying that these were design issues and that she should look to other people to respond to them.
Can we then go to ART 406157? This is an email you wrote to Peter Madison on the 7th of September 2015 on the subject of cost projections in response to his email of the same day to you, which you can see, well, you can't see at the moment. That's on page 2. I don't want to show you that. I just want to show you this email, which you sent to Peter Madison, and it follows a conversation you had with him that day, as you can see from the first paragraph. And in the last paragraph, if you go to that, he says, as I said in my voicemail, which you say in the first paragraph you left him earlier, I would like to have a conversation after the meeting on Wednesday, the resolution of design issues, which I do not believe are within our scope of services. Hopefully we agree where the divide in responsibility lies and all work together to give you the much needed information and confidence you need to report back to your board and residents. Now, before I ask you a question about that, can I show you what you say in your first witness statement, Mr. Cash, at page 63, paragraph 204. You say, in response to, or in relation to this part of this email, you say, once again, I felt it was important to re-emphasise AUK's role to the TMO and make sure that it understood that AUK was not responsible for design issues. Were you surprised by that even by this point in the project, September 2015, the TMO might not have understood the limitation on your role about design?
Yes.
You were surprised?
I was surprised that we were still having issues in that respect because there was a concern about an omission in the scope, in the employer's requirements that should have been picked up as part of the design.
Yes. So does that tell us that even at this stage, or up to this stage, there had been a degree of confusion within the TMO about precisely what Artelia's role was?
I don't believe it can be called confusion. I do believe that if it may be, it appeared to me that Peter Madison was trying to apportion blame for something that had been missed.
Did you ever have a conversation with Mr. Madison about the precise scope of Artelia's design role that you indicated you would have?
Yes, I did.
Do you know when that took place?
Subsequent to that email.
Right. And what did you tell him?
That it wasn't our position to make sure that the specifications contained that scope of works. It was down to the design team, so Studio E, Max Fordham and Curtains, to ensure that they captured all of the works necessary. Our contract sum analysis purely captured the scope of works in a roundabout way. It wasn't definitive.
I'd now like to turn to a different topic, and I may come back to this topic about roles later on. May not be the end of it, Mr. Cash, but let me turn to a different topic, which is initial procurement. I'd like to examine with you the initial stages, first of all, of the Grenfell Tower refurbishment project. Start, if I can, with Artelia's original appointment. So going back a little bit to where we were yesterday, in 2012. Now, according to the Artelia corporate statement for the purposes of this inquiry, Artelia were appointed to Calc as a number of things, and I'll just tick them off. Project lead, yes?
Yes.
Yes. EA, so employer's agent.
Yes.
QS, yes?
Yes.
CDMC, so
Yes.
CDM coordinator, and CDA, client design advisor.
Correct.
Right. And Studio E was the lead design consultant. I think we established that yesterday.
Yes.
Yes. And is it right that Artelia had gone through an OJU tender process and had a framework agreement with the TMO?
Not a framework agreement.
Right.
It was an OG process for an appointment for the particular project.
I'm so sorry. Quite right. So it had gone through an OJEU process, but outside a framework.
Correct.
I see. And then I think it's right that in April 2012, Artelia was appointed formally to the Grenfell Tower project.
We were invited to attend a meeting with a view to being appointed, yes.
Right. Now, were you surprised that you weren't required to follow a separate appointment process for the Grenfell Tower project as you had for the Calc project?
No, because the original Calc project had made reference to a potential follow-on project in respect of Grenfell Tower.
So it was treated. So the OJEU tender was essentially for both projects. Is that right?
Yes.
I see. Can we then look at the fee cap issue? This is a question that's come up before. Can we go to TMO 1301757? This is part of an agenda of the TMO board meeting, as you can see, on the 15th of November 2012. Confidential Grenfell Tower regeneration project. You see that? And the purpose of the meeting was to recommend to the board the progression of the detailed design and tender package phases of the Grenfell Tower regeneration project, and to recommend to the board the appointment of Leadbitter principal contractor for the pre-construction agreement phase of the project. That was the purpose of the meeting.
Yes.
And if you go to the second page, page 2, look at the bottom of the page at paragraph 5.4 under the heading Procurement. You can see there it says Appleyards. This is paragraph 5.4. Appleyards has been commissioned separately as a cost consultant, CC, employer's agent, EA, and construction design management coordinator, CDMC, and this fee commission is capped at $174,000 for the entire project. You see that?
Yes.
Was that cap to keep Artelia's fees below the OJEU threshold?
I don't know why there was a cap there.
You don't know. You can't help us. You weren't at this meeting, but you don't know why it was capped.
No.
If you look at paragraph 5.2, the meeting note records that the project design team has been commissioned by the TMO under its own contract regulations, and fees are capped at the EU procurement thresholds of $174,000, as the design team procurement for Calc did not include provision to incorporate the Grenfell Tower regeneration project. Did you understand that Studio E, if that's what design team refers to, had also been capped at $174,000 for the reasons set out there?
No. Not at that time.
When did you come to learn that at a later time, do you think?
When there was when it became apparent in meetings that the TMO wished to appoint all of the consultants under Studio E rather than individually.
And when was that, roughly?
It was not that, I think it was not that long after, I can't remember.
This is November 2012. So
I think it may well have already been talked about by that time.
Right.
I can't remember.
Well, let's see how we go. Can we go to TMO 2085033, please? This is an email between Claire Williams and Jenny Jackson of the 10th of January 2014. This is English dating, or UK dating. And we go to page 2. We can see Claire Williams' email to Jenny Jackson setting out the fee proposals, to which she is responding on page 1. Let's go to that. And Claire Williams says to her, Jenny, I had a good session with Artelia yesterday and understand a lot more, read the appointments. My resume is, and then she sets out there what her understanding is. And then if you move to the first item, 1, Artelia TMO appointment, and there are some details there about the fees. And then she says, this is based on a contract sum of 9.8 million. I have no issue with this, but understand that we would need to sign off the RICS agreement covering services scope. And then if you go to page 2, so I think page 3 is actually what I need. She talks about Studio E, yes. But under 4, Studio E, to be novated, this is the only one I would query, and then she talks about what's been paid to date, and explains that Artelia had sent an email on the 20th of November, and then she says, I cannot find their fee information now, but it totaled 180,000 under novation. First stage is F to G, I think, with 39,000, and H to J with 54,000. Then there was a massive 90,000 for stage K, which is the construction stage, and she sets out what stage K covers after that. Now, can we then go back to Jenny Jackson's response at the top of the email chain? I'm hoping I've showed you enough of this email. And if we need to get back into this email, we will. But if you look at the email at the top of the chain and look at her response to Claire Williams, the 4th paragraph there says, the fees for Artelia from September 13 look very low given the complexity of the project. I need to get their schedule of work sorted out next week so we can review. I would have expected the CDM and the QS fees to be much higher. My question is, having shown you this detail, was Artelia keeping its fees artificially low so that they were under the EU limit of 174,000?
No.
Can you explain why they were so low given the complexity of the project at this stage?
That was Jenny Jackson's opinion. I didn't believe that they were low.
You didn't believe they were low. Right. Can we then turn to your role in the procurement of other contractors and look at ART 405742 again, please. This is part of Artelia's QS services schedule we looked at earlier. Page 55 I want to show you, from July 2014. Page 55, as I say, this is part of Artelia's QS services schedule. If we look at tick box 1.4.1 on that page, under the heading 1.4, Pre-Construction IBA Outline Plan of Work 2007, it says, and this box is ticked, advise on tendering and contractual procurement options, prepare recommendations for the client's approval. Does that mean that Artelia had the obligation to advise as to the procurement of other contractors?
Of the contractors to carry out construction works.
Well, it says tendering and contractual procurement options. Does it not go a little bit wider than simply construction works?
No, I don't believe it does. The general understanding of this is in relation to the procurement of a contractor to carry out the works, and that then follows through in terms of the other scopes of services that carry on beyond it.
Does that tell us that there had already been a decision, or one is supposed to read into this, that the contract would be a design and build?
Not necessarily.
So, if not necessarily, why would you limit it then to construction works?
Because that's the general understanding. This is a general scope of services that's applied, and therefore you need to look at it in relation to the specifics of the contract itself,
Right.
or the project itself. This is relation to the quantity surveyor's duties in overall procurement of the contractor, and this is not looking back at consultants or anything like that.
Right. Now, specifically, the obligation as described there, however wide or narrow it is, sat with the QS role, yes?
For this, yes.
Yes. And so I think it was Tweech and Lim, as supervised by you, that would have the responsibility within Artelia for advising on tendering and contractual procurement options
Yes.
and for preparing recommendations for clients' approval.
Yes.
Yes. And would this obligation apply to all contractors? I mean, in other words, all those who were contracting with the client?
In terms of construction works, yes.
So you say only construction, not any other service?
No.
Well, let's move on then to Studio E. I want to ask you some questions about the process which was gone through to appoint Studio E to the Grenfell Tower project, if I may. Now, it's right, I think, that Studio E didn't go through any competitive process whereby it was appointed onto the Grenfell Tower project, was it?
Correct.
Did you ever raise any concerns about that?
No.
Why is that?
The team was carried over from Calc project, and I assumed that like ourselves, that there was provision within their appointment to be carried over.
Right. Were you aware that Studio E had never before worked on a project involving the overcladding of a high-rise residential block?
No, I wasn't.
If there had been a competitive tender, would its absence of experience in that respect have affected its score?
Not necessarily. It would have depended on what the selection criteria would have been.
Did you ever have any discussion, either with the TMO or within Artelia internally, about Studio E's experience and expertise in high-rise refurbishments?
Not about their particular experience, no.
Why is that? How can you account for the absence of any discussion about that?
They were a competent designer, and they'd proved themselves competent in terms of the Calc project as architect, and in terms of designers and architects, and we had no reason to doubt their competence in terms of being able to do the work on the Grenfell Tower project.
Well, why did you have no reason to doubt? I mean, after all, they'd been appointed onto the Calc project, which was a low-rise building, a school. Why did you think why did you have no reason to question their competence in terms of being able to do the design work on an overcladding of a residential high-rise building, which was a very different building altogether?
They were they'd already been brought on board before we were brought into the project, so there was an assumption in some respects that the client was satisfied that they'd be able to do the design work. The meetings that we attended, the way that they presented the options on the cladding showed that they appeared to have quite a knowledge of what they were doing, and I would refer back to our CDM role in terms of ensuring that the client would have met his obligations in satisfying themselves as to their competence to provide the services for the project.
Do you accept that the way in which Studio E was appointed, in other words, simply being transferred across from the Calc project to Grenfell, did not lend itself to a rigorous check and an analysis of Studio E's suitability for the Grenfell Tower project itself?
I don't know.
Well, I'm asking you to accept the proposition.
I can't say, because I don't know what checks the TMO may have made already.
Right. So do I take it from that when you came into the project from Calc, essentially, it didn't occur to you personally, or Artelia more generally, to examine the skill set, suitability, qualifications and experience of Studio E?
It wasn't our role to do that, other than as CDM coordinator, to ensure that the client met their obligations in satisfying themselves as to the overall team's competence.
Right. Were you aware that Studio E had or Studio E LLP, had financial difficulties in 2014.
No, I wasn't.
So you didn't know that the partnership, the LLP, was in administration and then wound up in August 2014. Did you not know that?
No.
If there'd been a competitive tender at that time, that might have ruled Studio E out, no?
If it had been apparent.
Right. Now, I just want to look with you at the Studio E cap of £174,000. We saw a little bit of that in the document we saw earlier, the 15th of November 2012 TMO board minute at paragraph 5.2.
Yes.
Let's just look at another document. This is Mr. Dawson, Alan Dawson's witness statement to the inquiry. He's Artelia. This is ART 408348, please, at page 10, paragraph 45. And he says there, it's not unusual to engage consultants up to a particular stage of a project. The design consultants' fees for stage C to D work were capped at £174,000 because the TMO were looking to have a single appointment with Studio E, then sub-consulting to the rest of the design team. My understanding was that under the OJEU regime, if there was a single appointment above £174,000, then the work would need to be tendered. The purpose of the cap was to avoid having to tender the work, as the TMO wanted the ultimate responsibility for the design to be all in one place, i.e. with Studio E. And I'll show you that. I just want to show you something else before we get to some questions. Can we look at ART 50168, please? This is the minute of a meeting of the 18th of July 2012, so early on in the project. And we can see who was present there. It was held at Appleyards. This is a Studio E document, and Paul Dunkerton from the TMO was there, and we have from Appleyards, Alan Dawson, David Hale, and Chweechan Lim, you see that, and Bruce Soames from Studio E. And in the first main paragraph under appointments, it says, A. Dawson gave verbal confirmation that all appointments are approved. However, the TMO would like to subcontract all consultants via Studio E up until stage D, with the total fee up until stage D not exceeding £174,000, which is the OJEU threshold for requiring work to be tendered. This will probably mean deferring some fees post-stage D. Now, as a qualified QS yourself, with oversight of this project and supervising Miss Lim, were you aware of this cap of £174,000 at the time?
I can't remember if I was aware at the time, but I think I became aware of it, yes.
When do you think you became aware of it?
I can't remember.
Right. Did Alan Dawson not report back to you what had happened at this meeting?
He probably would have done, yes.
Yes. You would therefore, I think, have understood that the purpose of the £174,000 cap for Studio E was say that the TMO would avoid having to tender for a new architect.
For the purpose, in terms of being able to bring all of the consultants underneath Studio E in a single appointment.
Yes.
Individually, they wouldn't have had to have done so.
Right. Did you ever discuss that purpose with the TMO yourself?
I can't remember.
Did you know whether anybody else in Artelia had a discussion about that approach?
I don't remember anybody specifically, but I suspect Alan Dawson would have done, yes.
Did you think at the time, if you had discussed it, that this was an appropriate arrangement?
I can't remember.
Right. Were you concerned at all from this point that Studio E might be keeping its design fees low deliberately to avoid the retender?
No.
Did you think that they were doing so because they were underestimating the amount of design input which this project required?
I don't think so, no.
Now, the course that was adopted, or was proposed, I should say, I think was approved by Artelia in the end. Do you remember that?
Yes, I think I do.
Right. Did you take any action yourself?
I can't remember.
Right. would you have expected someone from Artelia to have pointed out to the TMO that the approach they were adopting was a potential breach of the procurement rules?
Yes, and I can't remember if we did or not.
And it would have been, wouldn't it?
It would have been, yes.
Yes. And you can't remember whether you did or not. You would have expected someone within Artelia, surely, to have raised this with you for discussion so that you could actually discuss it with the TMO. No?
I can't remember. I can't remember the details, and whether or not somebody had already had the conversation with TMO, in which case it wouldn't necessarily have escalated to me.
Right. Are you telling us that you either weren't involved or don't recall being involved in any such discussion at all?
I don't recall.
Right. Who would it have been, do you think, who would have had that discussion with the TMO?
It would have been a combination of Alan Dawson and Chui Chen Lim.
Right. Can we then turn to design quality control, and specifically SEA's ISO 9001? Are you familiar with ISO 9001 of 2008?
I know of its existence. I'm not familiar with the contents of it, no.
Right. It's an international standard for quality management, isn't it?
Correct.
It's very broad. And did you know, or do you now know, that organisations which are registered as ISO 9001 compliant have been independently certified to have a quality management certification?
Yes, I'm aware of that.
And I think Artelia was itself 9001 registered, wasn't it?
Yes.
At the time of it being engaged formally in 2014.
Yes.
Yes. And I think you would understand or agree that being accredited and certified under ISO 9001 involved a pretty rigorous accreditation process.
I believe it does, yes.
Did Artelia ever check whether Studio E Limited as opposed to LLP, was ISO 9001 registered when it began to work on the project in and from mid-2014?
No, it wasn't part of our remit.
Why is that? It wasn't part of your remit?
Weren't responsible for checking their quality standards.
Right. Can we then go to the contract, page 47, ART 405742, page 47. This page is from the employer's agent schedule of services, which I think I'm saying for the third time now begins on page 45. We don't need to get back to that. Bottom of this page, we can see 1.3 design, RIBA Outline Plan of Work 2007. We looked at this before. And then we can go to the next page in a moment, but it's clear just on this that this is dealing with employers' agent services in relation to design, yes?
The design stage.
The design stage, all right, well, I'll take that for the moment. If we go to page 48, we can see the top of the page left-hand column. We can see that there is a box 1.3.2 right at the very top, and that's ticked, or crossed, in other words marked as applicable. Liaise with the professional team and establish a structure and procedure for quality management. Establish, review, approval, variation and reporting procedures. Prepare recommendations for the client's approval. Would the professional team, as referred to there, include Studio E?
Yes, it would.
It would. Given that this section is for the design stage services, as you have pointed out, would that mean that there would have to be established a structure and procedure for the quality management of the design?
Of how the design was being prepared for this project, and that would be captured within the project execution plan.
I think that is an answer. I think that's a yes, isn't it? Let me try it a different way. Do you accept that, given what we're looking at, sits within the part of these services related to the design stage, that Artelia's responsibility was to establish a structure and procedure for quality management relating to design?
Yes.
Yes. And based on this contractual obligation, do you accept that Artelia had an obligation to the TMO to establish quality management structures and procedures for the design in liaison with the professional team?
Yes.
Did Artelia, in fact, ever establish any such structures or procedures at this stage?
I believe they were covered within the project execution plan.
project execution plan. and I think that's something which sat with Chweech and Lim, isn't it?
No, with Alan Dawson.
With Alan Dawson, right, as the EA.
Correct.
Right. Do you know how Alan Dawson discharged that responsibility in practice?
He prepared a document that was issued.
And did that cover Studio E's own work?
It covered the work of the team and the project professional team generally.
That would include Studio E, wouldn't it?
Yes.
Because Studio E was part of the professional team.
Yes.
Right. Okay. And did that project execution plan contain any guidance or requirements as to the systems of, for example, tracking of drawings and design that Studio E were to maintain?
No, I don't believe it looked at Studio E's internal processes. No. It was
Why is that?
Because that was, for them, it wasn't part of our remit to look at their internal processes. It was about looking at the outputs and how those would be dealt with as overall in terms of the project.
Well, my next question is, was it not? Looking at the obligation, liaise with the professional team and establish a structure and procedure for quality management, did that not include making sure that Studio E internally had its own quality management procedures?
No.
Which would enable the proper execution of the project plan?
No.
Why is that?
I don't believe it's because it's not for us to interrogate each of the individual consultants as to how they carry out their work.
So what was the structure and procedure for quality management that was established with the professional team, do you know?
I can't remember.
You can't remember? Can you not even remember in outline what it was?
No, because it was, as I say, it was embodied in the project execution plan, I believe,
Right.
and I can't remember the detail of that.
Can we then turn to CDMC duties in the context of Studio E? We looked earlier at Artelia's obligations as the CDMC under the CDM Regulations 2007. I think that was yesterday. And we looked at the approved code of practice at paragraph 90. I think you recall that. Do you agree with this proposition that Artelia, as the CDMC on the project, was required to consider and provide advice to the TMO on the competency of Studio E?
I can't remember the clause.
Right, well, let's go back then to the approved code of practice. It's probably the best place to find it. This is INQ 3013936 at page 45, I think. And we look at paragraph 95 in this document. Yes, page 45, para 195. We looked at this yesterday, I think. To be competent, I'll read it again. To be competent, an organisation or individual must have A, sufficient knowledge of the specific tasks to be undertaken and the risks which the work will entail, and B, sufficient experience and ability to carry out their duties in relation to the project, to recognise their limitations and take appropriate action in order to prevent harm to those carrying out construction work or to those affected by the work. And look at 197 immediately below it. Appropriate experience is also a vital ingredient of competence. People are more likely to adopt safe working practices if they understand the reasons why they are necessary, and past experience should be a good indicator of the person's company's track record. And now if we go over the page to page 46, we can see para 199. We just look at that. What you must do, it says, all those with duties under CDM 2007 must satisfy themselves that businesses that they engage or appoint are competent. And then it says this. This means making reasonable inquiries to check that the organisation or individual is competent to do the relevant work and can allocate adequate resources to it. Those taken on to do the work must also be sure that they are competent to carry out the required tasks before agreeing to take on the work. For notifiable projects, a key duty of the CDM coordinator is to advise clients about competence of designers and contractors, including the principal contractor that they engage. Now, I've shown you that. Did you understand at the time that the CDM coordinator's role, which was one specifically assumed by Artelia, should have considered and advised on the experience of Studio E in overcladding a building?
If it was covered in our scope of service, then yes.
Yes. And do you agree that Artelia should have considered and advised on the use of other design professionals to assist Studio E in that task if they couldn't do it themselves?
I'm not sure where that comes into it.
Well, comes into competence, doesn't it? Making sure that the organisation or individual is competent to do the relevant work and can allocate adequate resources to it.
Their competency is as architects and designers.
Indeed. Did you understand that as a CDM coordinator, Artelia should have considered and advised on the financial standing and resources available to Studio E for this project?
I'm not sure what checks were carried out by Keith Bushell.
No, but as a general matter, my question wasn't that. My question, I'll ask it again. Did you understand that as a CDM coordinator, Artelia should have considered and advised the TMO on the financial standing and resources available to Studio E in relation to this project?
I don't think that's relevant to their competence.
Well, adequate resources, Mr. Cash, paragraph 199, says in the third line that you've got to make inquiries to check that the organisation or individual is competent to do the relevant work and can allocate adequate resources to it.
Yeah, sorry, yes. I was thinking more in terms of financial standing.
Right. Well, that would be related to the ability to allocate adequate resources, no?
I don't know.
Well, I'm asking...
I don't think so. Adequate resources would have been in relation to the people that were allocated the project, and they appear to be. I don't know what checks were carried out in terms of adequate resources.
Right. If Studio E were having financial difficulties, would that not be something you would want to know as a CDMC in order to be satisfied that they were able to allocate adequate resources to the project?
I don't believe it comes into the CDMC. It's about their competency to design.
Right. And then quality management, again, same question. Did you understand at the time that Artelia, as the CDM coordinator, should have or was obliged to consider and advise the TMO on the quality management processes of Studio E as part of their competence?
If it was within our scope of service.
Well, you say if it was within our scope of services. We've already looked at the CDMC duties under the contract and under the regulations. I would suggest to you that that was within the scope of your services. Rather than going back over old ground, it was within the scope of your services to ensure that Studio E was competent as defined in the ACOP.
I'm not sure what, as I say, I'm not sure what checks Keith Bushell had done or what he had agreed with the TMO in terms of checks of Studio E's competency as the CDM coordinator.
Right. So does that tell me that you can't help answer this question? Did Artelia provide any advice to to the TMO about Studio E's competency for this project?
Correct.
Can we then turn to a different topic, which is a slightly different topic, which is Leadbitter's initial appointment to the Grenfell Tower refurbishment project. Now, you cover this in your first witness statement at page 8, if we could just have that up, please, paragraphs 23 to 24. And in 23, you refer to the second design team meeting on the 24th of May 2012. We've looked at that earlier this morning. And then you say at paragraph 23, picking it up in the second sentence, you say it was noted that the TMO board needed to be persuaded that keeping with the IESE contractor under CULC was in both the project and the TMO's best interests. This was a reference to the fact that Leadbitter was the existing contractor on the CULC project, and one of the options for procurement of the building contract on the project was for Leadbitter to be awarded the contract. My understanding was that this was preferred by those attending the meeting from the TMO, as it meant, we can just go over the page, that the TMO would not have to go through a public procurement process to appoint a contractor on the project. I mean, in para 24, you go on to say, I also understand that their view was that maintaining Leadbitter on the project would also in principle provide value for money because they were already working on the adjacent CULC site, and in terms of practicalities and logistics that would provide some savings, that would provide some savings over having an entirely new contractor having to come to site and set up. Now, I think you weren't at that meeting, as you told us earlier. This is the second design team meeting of the 24th of May 2012.
Yes.
where you've set out what you say there in your statement that I've read to you at some length, did you take your conclusions there from the minutes that you read?
Yes.
You did. And you say, as I've shown you, at the bottom of page 8, top of page 9, within paragraph 23, that the people at the meeting preferred to stay with Leadbitter at this time because it meant that they didn't have to go through a public procurement process. Why would some people at the TMO prefer not to go through a public procurement process to appoint a contractor on the Grenfell Tower project?
At this particular point in time, the primary focus was on programme, and to go through a public procurement process would take several months. And therefore, if there was an option of being able to bring a contractor on board through an alternative means that saved them time, then that would obviously help them.
Right. Was there any, to your understanding, any discussion about the preference for not having a public procurement process, anything to do with cost?
No.
Can I ask, just in general terms, we'll come to the re-tender later this afternoon. In fact, we're going to come to it next. But before I get to it, do you know, in general terms, why a design and build contract was chosen as the form of contract
I
for the
believe
Grenfell Tower project?
I believe that's because that's what we had on the Calc project. And I can't remember the specific conversations in relation to how the decision was arrived at, though. I'm not sure whether there were discussions about other alternative forms of contract.
Well, do you remember any discussions about an alternative form of contract?
I wasn't involved in any particular discussions that I can remember, no.
Right. Was there any consideration given to whether a design and build form of contract was suitable for a major refurbishment of an existing building such as Grenfell Tower?
I can't remember.
You can't remember. You can't remember that. Do you remember whether Artelia ever gave any advice on alternatives
I can't remember.
or the form of contract which TMO should enter?
No, I can't remember.
Mr. Chairman, I note the time, it's 5 to 1. I'm about to turn to a different topic. I'm very happy to continue for 5
Well,
minutes.
there are only a couple of minutes to go before the usual time for a break.
Yes.
So, it's a new topic.
It's a new topic, and I'm happy to start and have 5 minutes on it. Use the 5 minutes.
You
that are
won't
there.
get 5 minutes.
No, it won't take 5 minutes.
No, 2 minutes.
Well, all right. Well, in which case, I think I'm getting the impression that this is an appropriate moment.
Well, if you're going to start a new topic, it would seem more sensible to do that after we've had
I think it
a
would, yes.
break.
Yes.
Yep, all right. Well, Mr. Cash, as you can tell, we're about to have a break now so we can all have some lunch.
Thank
We'll
you.
come back and resume your evidence at 2 o'clock, please.
Thank you. Will
And
do.
please remember not to talk about your evidence or anything related to it while you're out of the room.
I won't.
All right? Thank you
you.
very much. We'd like to go with the usher, please.
Thank you.
Thank you very much. 2 o'clock, please.